my lord. Politeness includes
Yes, sir,
following
sir.
the procedure of court.
Only request is that please, as minimum,
I only asked for the permission. I started with the Lordship's most gracious permission, with the permission of the most gracious.
Addressing your lordship on, my lord, the application of the essential religious practice doctrine. My lord, to save time, my lord, I have prepared a note which only gives, my lord, the instances from reported judgments where this principle has been applied.
only interrupting for a second,
Yes.
Mr. Jadi, because
Yes.
we have a very distinguished guest with us today.
Yes, my lord.
There are 4 honorable judges from the Royal Court, Supreme Court of Bhutan with us. Justice Sangya Khandu, Justice Kinle Dorji, Justice Pema Wangchuk, the 3 honorable judges from the Supreme Court of Bhutan. Then we have Chief Justice, High Court of Bhutan, Justice Duba Rupka. We also have Registrar General of the Supreme Court of Bhutan, Madam Sonam Gelstein. Then Director General of the Bhutan National Legal Institute, Mr. Preman Nedu. Madam Sonapi, the Chief in their IT officer of the Supreme Court of Bhutan. Then we also have 2 assistant judges of the Supreme Court of Bhutan, Madam Dechen Somodozi and Jigme Singha. And we also have the court registrar, Mr. Tingle, with us, the entire delegation from the Supreme Court of Bhutan. They are here on an official visit. They are our guests and part and parcel of our extended judicial family.
My lord, on behalf of everyone in bar, my lord, we welcome all the dignitaries, my lord, in before one of the finest courts in the world.
And my lord, the size of the bench has now gone up, my lord.
All women, my lord, all women.
Now, my lord, before I conclude this, my lord, I'm handing up this note, my lord. The notes which I'm giving your lordship, my lord, I don't read. What I have done is I've collected only the facts. Just to give an example, my lord, your lordship may see it in at your convenience, my lord, and I have to go on to the next topic, my lord. I'll give an example only and move on as to what is the substance of this note. For instance, my lord, in the Anandamargi case, which is, my lord, Abadut, whatever, Jagdishwaranand, in that case, my lord, they used to take out processions every year in which they used to perform the Tandav dance. Now, the Tandav dance is part of their religious practice, no doubt, but they were served with 144 notices because there was a breach of peace apprehension. They challenged 144 notices saying that they have the religious right to practice that Tandav dance in public. That thing was extra, public. So, my lord, they challenged 144. This honorable court held that yes, we accept that Tandav dance is part of your religious practice, essential practice, but it is not essential for you to perform it in public. So therefore, the 144 notices are valid. My lord, like that, my lord, I've just culled out all the facts of, my lord, a few cases where this debate has come up, and your lordships have resolved. So, my lord, I leave it at that, my lord. I move on to my next topic, which is, my lord, something which has been troubling your lordships from the very beginning. Two questions together. One is, if these kind of tests are to be applied by a court, then what is the method by which you will proceed? And for that, my lord, the first proposition is that it has been settled in case after case after case that it is to be ascertained religious practices and whether they are essential or secular. These are to be ascertained with reference to the doctrines of the religion itself. It's not the judicial view. My lord, please, my lord, now keep aside the question of judicial review of religious practices. That is when, my lord, the judiciary is asked to consider whether a particular religious practice should be allowed to be performed. This is not that. This is, my lord, adjudication. Adjudication as to whether a particular religious practice is followed by individuals or denominations, and whether these practices are essential and whether these practices are secular or are they religious practice. These debates, my lord, will continue to arise in front of your lordship, my lord, from time to time, and there's no, even if your lordship, my lord, does not go into judicial review at all, this job will continue to remain with your lordship, my lord, and there is no getting out of it, my lord.
There is no dispute on that.
Lordship. Now, so therefore, my lord,
Otherwise, you can't test the law under 25(2)(a).
yes, quite right. Every time you do that, my lord, it has to be done. Now, my lord, paragraphs 42, 43, 44, and 45 of the my lord, my written submissions deal with this aspect, my lord, and please just have a look at only, no, my lord, it's not necessary. Your lordship, my lord, has been exposed to this sufficiently, my lord. I now come to an even more important question, my lord, which your lordships have raised. Can the court do it? And my lord, I only want to place, my lord, two places where your lordships have said it is difficult, but we have no option. It is our duty to do it, my lord. For that, my lord, if your lordship doesn't mind, my lord, kindly take paras 53 to 55 of my note, which are extracts. And I wish to place these extracts, my lord.
Paragraph 66.
53, 54, 55.
This
The
is of a additional written statement.
Yes. Additional written submissions. Correct. The original written submissions are bare answers. As I told you, Lordship, my lord, this is lengthy. Just
63 internal page 20, regular
17.
paper book page 20.
17, my lord,
17.
in the hard copy. 53. Not 63, my lord, 53.
53.
Yes.
Oh, that's it.
Page 17.
17.
Yes.
Open occasion will arise. Huh?
Yes. The first one is from
Right answer.
Adi Shaiva judgment of Justice Gogoi, my lord. Often occasions will arise when it may become necessary to determine whether a belief or a practice claimed and asserted is a fundamental part of the religious practice of a group or denomination, making such a claim before embarking upon the required adjudication. A decision of such claims becomes the duty of the Constitutional Court. It is neither an easy nor an enviable task that the court is called to perform. Performance of such task is not enjoined in the court by virtue of any ecclesiastical jurisdiction conferred on it, but in view of its role as a constitutional arbiter. Any apprehension that the determination by the court of an essential religious practice itself negates the freedoms guaranteed by 25 and 26 will have to be dispelled by the touchstone of constitutional necessity. Without such a determination, there can be no effective adjudication whether the claimed right is in conformity with public order, morality, and health, and in accord with the indisputable and unquestionable notions of social welfare and reform. A just balance can always be made by holding that the exercise of judicial power to determine essential religious practice, though always available, being an inherent power to protect the guarantees under Article 25 and 26, the exercise thereof must always be restricted and restrained. Milord, I also bow down, Milord, that all restraint should be exercised when you are dealing with religious practices. This is not like any other tax case or, Milord, where nobody's emotions are involved. Citizens' emotions are involved, and so therefore, Milord, extreme restraint should be exercised, no doubt about that. But, Milord, sometimes, Milord, it has to be done. Milord, there is another passage, Milord, from the Tilkaya judgment. I won't, Milord, multiply. Now, and here, Milord, I would only wish to end by saying this topic, that it is not substituting your Lordship's views when you decide on these questions, Milord. It is not your views, Milord. You are taking evidence and you are accepting or rejecting the material put before you as to what the persons involved with the religion think about it, Lordship. Now, Milord, I come to 25(2)(a). It will take, Milord, just 5 minutes. Now, here, your Lordship has seen, Milord, sometimes there is a conflict between different religious practices, either within the same religion or between two religions. Here, Milord, is a different conflict. This conflict is between whether it is a religious practice or it is a secular activity associated with religion. That's, Milord, the language of the Constitution. Religious practice or secular activity. Now, Milord, your Lordship had at one point said, is there a test for it? The only judgment, Milord, which talks about a test for this particular determination is the Ratilal judgment, and it says that common sense will have to be applied. Now, Milord, it may not, Milord, help that much, but this is the only thing we can find as to how you will decide whether it is secular or religious. Now, Milord, here my submission. You can draw the balance on one side or on the other side. Now, Milord, what happens is, ghee, your Lordship was mentioning. In the Shirur Mutt case, Milord, how much to use? Now, a person, Milord, who is steeped in the scriptures and all that, may want to draw the balance towards religious practice. But a person, Milord, who is looking at it purely from a constitutional point of view, may want to draw that balance, Milord, towards secularism. So therefore, Milord, it is something which your Lordships will do. I am not here, Milord, saying lay down any principles for it, but, Milord, it is, Milord, a test which has to be devised or not devised, Milord, and left to, Milord, each court to go into as in an appropriate case. Now, in this context, Milord, I am going to deal with a set of submissions regarding the Sheshammal case. My learned friends, Milord, have asked your Lordships to overrule Sheshammal's case. Milord, first of all, Milord, I respectfully submit that Sheshammal's case does not incorrectly deal with the law. The law that Sheshammal is applying is 25(2)(a). That is to say, is it a legislation in respect of secular activity associated with religion, or is it a legislation dealing with religious practice? Now, what was, Milord, the question? The question was, Milord, under the Tamil Nadu Act, HRNC, by 1969, I think, Milord, they had decided to amend the Act to bring in a provision that hereditary appointments to the post of Archakas is to be abolished. Archakas are certainly religious persons. They have to be trained in the religion and in the agamas, etc., etc. However, the question was that amongst persons who are trained, should we only confine ourselves to hereditary transmission down the families? In deciding this question, Milord, two questions were answered. One was that actual process of appointment of an Archaka all of whom are duly qualified, is something which is secular activity associated with religion. Number one. But number two is also very important, my lord. It's not necessary just now. But number two is very important, my lord. Relying, my lord, on a report by Mr. C.P. Ramaswamy Iyer, it was said he had given a report saying that this has become a pernicious practice and is creating a problem. And therefore, my lord, this honorable court said that it could just as well be social welfare and reform. So both of these two were there.
Mr. Jaidev.
Yes.
To say that there is no hereditary right is one thing.
Yes.
By way of a social welfare legislation, if the state wants to bring in.
Yes.
And say others can also perform the duties.
Yes.
That is different.
Yes.
By bringing that, they
Yes.
can wipe out the right of the hereditary rights.
Millard, hereditary persons who are trained in the agamas will certainly be able to apply, but they cannot claim it as a matter of right. That's all.
If it is continued for long.
Yes.
And it is a part of the religion.
Yes.
Why do you want to deprive that? You bring in social legislation.
It is never part of the religion, Millard. That is what Sheshammal says. That how you will appoint the person is not a matter of religion. What they do, what their qualifications are required is a matter of religion, but not this. And my lord, here, if your lordship just sees paragraph 67 for a minute, my lord, because this is an aspect I just wanted to, my lord, highlight before your lordship in some context, because you have to keep it in mind, my lord, in taking an overall decision in the matter.
Yes,
Page 21, para 67. In this context, it may be pointed out that this honorable court held that the legislation could be supported also on the ground of social welfare and reform, inasmuch as the legislation was based on the report of Hindu Religious Endowment Commission 60 to 62, headed by C.P. Ramaswamy Iyer. This report pointed out that there was, and the rest is quotation, there was a crying need to reform in this direction, since the hereditary principle of appointment of archakas had led to grave malpractices, practically destroying the sanctity of worship in various religious institutions. So it was a move, my lord, in the direction of social reform also.
See, the process of appointment,
Yes,
recruitment or whatever, that is secular.
that's it.
But the qualification.
Qualification is religious.
That is strictly religious.
Strictly religious, my lord. No
Because
question.
What are the qualifications, the agamas that they have to know?
Yes, yes.
The method of worship
Everything.
for that particular deity.
Yes.
They are all strictly religious
Absolutely,
practices.
my lord. No question about it.
So therefore, there is a line to be drawn.
Entirely, my lord. And your lordship may note that archakas who are appointed now are trained in institutions
Yes.
on the agamas and all rules which have to be followed. Number one. Number two is they cannot belong to some other agama. This is why, my lord, just now there is a whole series of litigation.
Basically, in South, there are two agamas, the Shaivite agama and the Vaishnavite.
Yes, my lord.
So they are trained in that particular
And my lord,
denomination.
yes, and today's legislation is such that if you are from the Shaivite agama, you will have to know that.
Yes.
You cannot appoint a Vaishnavite agama into that.
It is a strictly religious
It is
practice.
strictly religious, my lord. There is no question about it. Now, my lord, I move on to 25(2)(b) now. Just one more thing, my lord, that the legal proposition applied in Seshamma is undoubtedly correct because it is 25(2)(a) and 25(2)(b). Which way the line will be drawn is a matter of fact in each case. So therefore, my lord, your lordship may wish to reconsider Seshamma, but my lord, that has to be specifically done on the facts of that case and not, my lord, while dealing with legal propositions. That's my submission. Now, I go on to, my lord, 25(2)(b). 25(2)(b), my lord, is extremely important. I'm keeping it open in front of myself, my lord. If it can be kept open, my lord, on the screen also. There are a few words here, my lord, which are important. Number one, the first one, my lord, I am not spending time on. 2A, I have finished, my lord. 2B, two parts, my lord. Providing for social welfare and reform. This is one part. Second part is, and the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Now, As far as, my lord, social reform and social welfare and reform is concerned, I only wish to make one comment, my lord. Why is it to be found in, my lord, the articles on religion? If it is only social, then what is it doing in the article on religion? And the reason why it is there, my lord, I beg to, my lord, submit, is because social rules have sometimes been sanctified by making it a religious practice. So if you want to reform the social rule, you will have to touch on religion. And therefore, my lord, the state has been given that power. My lord, this is not judicial review. This is not about the court deciding. This is about the state deciding, and it being made absolutely clear that when the state goes into this question, it is not entrenching on the religious rights, because a separate compartment has been created for it in the constitution itself. So therefore, my lord, social welfare and reform is here because social rules are sometimes raised to the platform of religious rules and sought to be enforced in that fashion. Very simple, my lord. Tanks were, my lord, forbidden for certain caste configurations. People bathe in the tanks. That's not a religion as such. I'm not talking about a temple tank just now. Even, my lord, tanks out in the roads used to be restricted for certain classes and castes. When that happens, they raise it to the question of religion and say that this is so because. Now, you will not be able to, my lord, make that social change unless you entrench upon religion.
That is
So,
already there in Article 15(2).
15.2 is there. So I'm just giving an example, my lord, that 25(2)(b) specifically includes social welfare and reform, because sometimes in order to reform social rules, you have to entrench on religious rights. So this is to make it clear that nothing will prevent the state from making such a law, despite what is there in 25(1) and 26. Now, next point, my lord.
Yes.
One of the main aspects of social reform, I respectfully submit, was the throwing open of Hindu religious institutions of public character to all classes.
Is made.
Yes.
Article 25(2)(b) in the name of reform.
Yes,
It cannot violate what is guaranteed under Article 25(1).
it can.
Cannot.
No, it
cannot
can, my
violate.
lord. That is my whole submission. It can.
No doubt it is an empowering the state.
Yes.
Social reform.
Yes,
But it cannot hollow out religion.
it can, my lord.
It's guaranteed under Article
My lord,
25.
hollow out is a strong word. my lord.
Has to be seen, that is judicial review.
No, that's not judicial review. State has done it. Now see this, my lord. See the language.
Challenged, if the state has exceeded its limits, the judicial review is always possible.
So the limits cannot be exceeded merely because it is guaranteed under 25(1). Because 25(1) is
Yes, it comes under the subject to clause.
no,
Public order.
it certainly
safety,
comes.
And health.
Millard, it certainly comes. It has been held so. Let me just read that first part of Millard 25(2)(b). Nothing in this article shall affect the operation of any existing law or prevent the state from making a law for this purpose. What does this mean, Millard? And 25(1) is subject to this. So therefore, it is specifically, Millard, carved out, because as your lordships have been repeatedly told correctly, that an essential part, my lord, of Hindu religion is the right to worship an idol. The right to worship being so important, and the right to worship in Hinduism at least has to be carried out in a consecrated place, a temple. If you exclude people from it, you are excluding their right to practice the religion. Yet, we have a history of temples excluding people. So therefore, faced with this problem, two things were, Millard, in my respectful submission.
I didn't say on exclusion.
Yes.
The social reform.
No.
Social reform
Yes.
cannot, in the name of social reform, breach or violate the freedom guaranteed under 25(1) to
Millard,
an individual.
I will respectfully, Millard, submit this proposition in this fashion, that you cannot hollow out the entirety of the religion. But social reform, if it requires change, in that event, and if you do it, somebody will not be able to use Article 25(1) against it.
No,
Because-
Mr. Gupta.
Yes.
Where we have to
Addition-
balance out.
In addition to what sister is saying.
Yes,
See, suppose there is a religious practice.
yes,
For example, in Guruvayur temple. They
right.
close the temple, I think 8 times or 10 times a day
Day, yes,
for some rituals.
correct.
There'll be heavy rush.
Yes,
There'll be a number of people will be waiting.
yes,
So under the guise of saying that it is causing public nuisance,
yes.
under the guise of social reform, can they say, no, you
Milord,
stop it, you
no.
restrict it to only 3, 5.
Milord, speaking for myself, Milord,
can't-
I am sure your lordship will not accept
Right.
that kind of reform.
That is the right given under 25(1). You
Yes.
cannot encroach upon that right.
Mr. Gupta, that was the question in Devaru.
Yes, correct.
And in Devaru, the hours were considered to be a part of religious practice, but
Correct.
not exclusion of classes
Yes.
or categories.
Milord, I'll give another example, Milord. Tilkhayat deals with, Milord, the Nathdwara temple in near Udaipur. There also, Milord, there is what is known as Jhaki Darshan. The God only reveals himself for a brief period of 15 minutes at certain times in the day. Now, nobody is saying, Milord, that that can't be done. In Devaru also, as my lord said, it was found that sometimes you cannot go in. Nothing wrong with that. It has to be followed. But to exclude the person altogether is not.
Exclusion is different.
Exclusion is different.
Very different.
Social reform,
Yes.
that is different.
Now, as you read these judgments, your lordship will come across extracts of various, my lord, previous judgments. One is Gopal Mupannar. Judgment is referred to in many places. Adishaiva cites it, Devaru cites it. My lord, in Gopal Mupannar, my lord, an agama is quoted, which says where people are to be standing when the puja is going on. But the fourth category in that Gopal Mupannar are those people who are supposed to be satisfied with the view of the Gopuram only. What does that mean, my lord? It means that they can't come into the temple. You have to be, there is a class of persons, according to the Agama, who have to be satisfied by staying outside the temple. My lord, therefore, this kind of Agama, my lord, should not, my lord, be practiced. And where will you get the power, my lord? State will have to have the power. It is very difficult for the court, my lord, to exercise such powers. I bow down, my lord. It's very difficult for the court to exercise. Yes.
We'll sum up your argument.
Yes.
25(2)(b) stands on a different footing.
Yes.
It gives power for you, enabling power to deal with the social reform. That when you talk about a social reform, obviously it interferes with the religious belief or a practice.
Yes.
But
Yes. Yes.
while
Correct.
deciding a social reform, you have to close your eyes with the religious practice or a belief.
Yes.
Find out whether exists a social reform or not.
That's right.
To that extent, the power of even the state will have to be very exercised very sparingly,
Yes.
and so also the court.
My lord, I bow
We'll have to see whether it exists.
My lord, your lordship has perfectly
Yeah,
summarized.
we understand your
And my
point.
lord,
All right.
if we follow that principle,
That's
then
correct.
what
We
your
understand.
lordship
Yes.
has said,
We
that will
appreciate
not pass muster.
Yes, please go to the next.
The legislation will not pass muster.
Yes.
Now, next thing is this, my lord. We have to first of all understand a little bit more about what is a religious institution of public character. Private and public, because, my lord, this question is being raised on the other side. Respectfully, my lord, if your lordships look at the totality of the judgments, it is a public character if any worshipper who is a Hindu may worship in that temple. And it is private if it is meant only for the worship of a private group of persons. It depends, my lord, on what the temple allows. Devaru was a denominational temple, so therefore it was meant or dedicated, my lord, to the Gaur Saraswat Brahmin community. But people, the lay public could enter with permission. And the finding in the judgment is that permission was never refused. So based on that fact, it was held that this is a temple, a religious institution of public character. Now, this therefore, my lord, they went on to say in Devaru that therefore a denominational temple can also have public character if that is what it is doing. It is a matter of fact. Now, next thing is, my lord, this is, my lord, how is it to be determined? There is one judgment, my lord, which talks about the facts which are relevant to be gone into. If your lordship wishes, my lord, para 73 I may place for 1 minute, my lord. Para 73 at page 23. I'll read, my lord, your lordship may just. The question of whether a temple is a private or public is primarily one of fact to be determined on the basis of circumstances. As held in Goswami Sri Mahalakshmi Vahuji versus Ranchod Das Kalidas, the origin of the temple, the manner in which its affairs are managed, the nature and extent of gifts received by it, rites exercised by the devotees in regard to worship therein are relevant factors to establish whether a temple is a public temple or a private temple. So this is how your lordships would do that, my lord, aspect. Now, here, if I may, my lord, draw your lordship's attention only to one question which is relevant for Sabrimala, because it's a legal proposition. It's not a factual proposition. It's a legal proposition which your lordship has framed as question number possibly, my lord, 4. Is it 4? Section of Hindus. My lord, your lordship has framed a question. What is a section of Hindus occurring in Article 25(2)(b)? Question 6 is that, my lord. What is a section of Hindus? Now, my lord, in Devaru, an elaborate argument was made that 25(2)(b) was meant for XYZ reasons. And so, therefore, the meaning of 25(2)(b), when it says all sections of Hindus, ought to be as discussed while framing it. Final answer given by this court is, my lord, page 32. Just have a look, my lord. It is relevant for Sabrimala, but it is not determinative. My lord, please don't think that because this is so, therefore Sabrimala will have to be allowed. Look at 32, my lord. Para is 106. So the answer to this contention, the question was, who are sections of Hindus?
Yes.
Answer to this contention is that it is impossible to read any such limitation into the language of 25(2)(b). It applies in terms to all religious institutions of a public character without qualification or reserve. As already stated, public institutions would meet not only temples dedicated to the public as a whole, but those funded on the benefit of the sections thereof, and denominational temples would be comprised therein. The language of the article being plain and unambiguous, it is not open to us to read into it limitations which are not there based on a 1957, sorry, Miller, that is wrong. Please delete 1957, it's a typographical error. Based on a priori reasoning as to the probable intention of the legislature. Such intention can be gathered only from the words actually used in the statute, and in a court of law, what is unexpressed has the same value as if it was unintended. We therefore hold that denominational institutions are within 25(2)(b). If you apply this principle of interpretation, sections of Hindus would include women.
Well,
now, next point, my lord, I come now to the most difficult part of my submission. And my lord, the way I am looking at it, my lord, given the time constraint, I will stop with this proposition only. The rest of the propositions, my lord, people have dealt with, so I'm not going to go into.
yes, you can just briefly.
I'm only going to show now come to 26. Now, 26 is difficult. First of all, my lord, it talks about religious denomination and doesn't define religious denomination. Now, whenever you are confronted, whenever the court is confronted with a situation that a word is used which is not defined, the first and most important thing that your lordship does in hundreds of cases is to check the dictionary. Therefore, my lord, in Shirur Mutt, the dictionary meaning of religious denomination was taken. Now, before I proceed any further down this route, my lord, it has been suggested to your lordship that the Hindi word sampradaya should be used, not the English word religious denomination. Now, my lord, the history of, my lord, the Hindi word has to be taken into consideration. The Constituent Assembly categorically rejected the demand that there should be a constitution in English and in Hindi. And then proceeded, my lord, to pass only the English. Seeing that this might lead to an issue later on, Mr. Rajendra Prasad got the members of the Constituent Assembly to sign a separate document, which was a Hindi translation of the Constitution. A separate document, not passed by the Constituent Assembly. That remained as it was. So, my lord, when Shirur Math considered this question, it did not have the benefit of looking at, my lord, any Hindi definition. The question should normally arise, my lord, why did they not look at the Hindi definition? There was no Hindi definition at that point of time, which had any authority. 1958, or is it? It's 1957 actually. By the 58th Amendment, Article 394 is introduced. 1987. I'm so sorry. Yes, my notes are wrong. 58th Amendment, 1987, Article 394, capital A is introduced. My lord, may I request, my lord, the board to reflect 394, capital A. Because, my lord, it has been argued before your lordship that if there is a conflict between the English and the Hindi word, then the Hindi word should be accepted. It is exactly the opposite. 394A, page number of?
Yes, you may.
Just 394 capital A. So, my lord, I am reading. The President shall cause to be published under his authority. A translation of this Constitution in the Hindi language signed by the members of the Constituent Assembly. They wanted, my lord, that document to be revived, the one that Dr. Rajendra Prasad had obtained signatures on. So that translation signed by the members of the Constituent Assembly with such modifications as may be necessary to bring it in conformity with the language, style and terminology adopted in the authoritative texts of central acts in Hindi language. So if between that date and this date, Hindi statutes have come into existence and a word has been used, the President can take that into consideration. And incorporating therein all the amendments to the Constitution made before such publication, and B, the translation in the Hindi language of every amendment to the Constitution made in English language. My lord, going forward, B talks about the future. A talks about the past. Now, look at, my lord, 2. The translation of this Constitution and of every amendment thereof published under clause 1 shall be construed to have the same meaning as the original thereof. Original is English. And if any difficulty arises in so construing any part of the translation, the President shall cause the same to be revised suitably. The Hindi version. The Hindi version can be revised by the President. Of course, my lord, the English version cannot, except in accordance with Article 368. So, my lord, if at all, I'm not.
Please read sub-article 3 also.
Sorry, madam. Yes, subsequent.
Sub-article 3.
Certain. Just 1 minute. The translation of this Constitution and every amendment thereof published under this article shall be deemed to be for all the purposes authoritative text thereof in the Hindi language. So therefore, my lord, both have to be taken into consideration. I am not saying don't take it into consideration. I am only saying that if at all there is a conflict, which of course, my lord, in this case, I do not see. But if there is a conflict, then the English language is the authoritative text. And you have to keep it in mind. You may want to, my lord, come to some conclusion, which is, my lord, after, my lord, harmonizing it, etc., etc. Now, but in this case, my lord, there is no conflict. There is no conflict because the English word, which is used, my lord, by the Shirur Math case. Now it is a little important, my lord, for your lordship to just take a look at that. Now, Millard, I'll stop by quarter to 11, quarter to 12, because we started at quarter to 11. So Millard, kindly come to 26. That is page 23 onwards. Para 75.
So what you understood, Mr. Jaideep,
Yes,
is that denomination should not, should taken to be the authentic for determining this issue rather than sampradaya because of 394A.
Millard, all I'm saying,
Probably what you're saying is appears to
Millard,
be,
actually-
appears to be correct,
Millard, yes.
because Hindi is only to be taken as the authoritative translation,
Correct.
not for determination of the
Determination.
point with.
And if there is a difference,
Suppose you have to have a translation in many languages.
yes,
The Hindi version would be this version.
that's correct.
But-
And also, Millard, if there is a difference, then the president has the power to bring it in line with the English version.
That too only for the purpose of the translated version.
Absolutely.
But any determination has to be in the English
In
version.
the English. That's my submission, Millard.
When he speaks about translation, he speaks about original also. That's the distinction.
Sorry, Millard?
When he speaks about translation, he speaks about original.
Yes, correct, correct. Now, the original, of course, is English, Millard, because the Constituent Assembly has not passed anything else. Now, para 75 of my note, if your lordship sees, this is little important, Millard, because to my, yeah. Now, no reason, Millard, kindly allow me, Millard. Oxford Dictionary to mean a collection of individuals. Therefore, Millard, what are we dealing with? We are dealing with a group. The institution is not the beginning here. The group of individuals is the beginning here. Classed together under the same name, a religious sect or body having a common faith and organization and designated by a distinct.
This is how it has been understood throughout.
Millard, actually, that's what I want to say. If all through, Millard, this is exactly what has been followed. And there is nothing wrong with this. And I don't believe, Millard, that the word sampradaya will come in conflict with this. If it came in conflict with it, Millard, it has to be somehow, Millard, harmonized.
According to you, denomination and sampradaya are also one and the same thing.
They are one and the same thing for the purpose of the constitution.
That's
Millard, if there is some other document, it may mean something else altogether. Now, if this is the position, Millard, it is a group of individuals who are given certain rights. Now, the Shirur Mutt, no dispute arose as to whether it is a religious denomination or not. Why, Millard? They were disciples of Madhavacharya. But a subgroup of that, Shivali Brahmins. So the court, having looked at the definition, said, well, obviously it is included. Madhavacharya, section thereof, Shivali Brahmins. Obviously it is included. It wasn't something which fell for determination in any great way. But in afterwards, Millard, cases did come up, Millard, where the question became important. And when it became important, Millard, they stuck to this classification. Now, the sum and substance of, Millard, all the other judgments is that they kept on one side this kind of organization, the mutts and all that, where there was a religious leader who was reforming the religion and he had his disciples, a very definite body, often, Millard, found in a textbook, book. And on the other side, they kept those temples which were actually general Hindu temples, in the sense that no specific body of precepts was identified with it. So, my lord, just to give example, the Ramakrishna Mission is a religious denomination. It is founded by Swami Vivekananda and another 8 disciples, another 7 disciples of Thakur Ramakrishna, not by Thakur Ramakrishna. This denomination, Thakur Ramakrishna was a priest. He was not part of Ramakrishna Mission. He was a mott. He was a priest in a Kali temple, separate from my Lord Ramakrishna mott. So therefore, the body of principles that he preached, a group of people got together and decided to follow it. And that becomes a religious denomination. Now, one passage which shows that this is something which was happening in this country, and therefore it was it was, my lord, adopted by this honorable court, I respectfully submit. That passage, my lord, if I may show your lordship from para 90 of my note. Page is, my lord, 27. Because this explains to some extent the difference between the two classes which I have indicated just 2 minutes back. Para 90, page 27. The development of Hindu religion and philosophy. My lord, this is taken from Adi Shaiva, but it's actually a quotation from another judgment, my lord.
It's from Devaru, it was read out.
Sorry. This is from the Swaminarayan's judgment, my lord, actually, but quoted in Adi Shaiva. The development of Hindu religion philosophy shows that from time to time, saints and religious reformers attempted to remove from Hindu thought practices element of corruption and superstition, and that led to the formation of different sects. Buddha started Buddhism. I don't know, my lord, whether Buddhists will agree with this, my lord, that they are a religious sect under Hinduism, etc. Mahavir founded Jainism. Basava was the founder of the Lingayat religion. Dhyaneshwar and Tukaram initiated the Varkari cult. Varkari cult. Well, normally I try to, my lord, get the pronunciation right, but I didn't have time to, my lord, find this one out. Guru Nanak inspired Sikhism. Again, whether the Sikhs will acknowledge that it is a denomination within Hinduism, my lord, I don't know. Dayanand found Arya Samaj and Chaitanya found Bhakti cult. And as a result of the teachings of Ramakrishna and Vivekananda, Hindu religion flowered into its most attractive, progressive and dynamic form. If we study the teachings of these saints and religious reformers, we would notice an amount of divergence in their respective views. But underneath that divergence, there is a kind of subtle, indescribable unity which keeps them within the sweep of the broad and progressive Hindu religion. So finding that such a tradition existed in this country, these are the kind of, my lord, institutions which they took to be religious denominations. That's what your lordships have done. Now, whether something else is possible or not, my lord, of course, my lord, your lordship may have some other view on this matter, my lord, and not for me to say no. But the only argument that we have heard so far is that religious denomination is the same as religion. In other words, Hinduism is a religious denomination. Respectfully, my lord, it goes against the plain.
I don't think they have said that.
Yes.
Hinduism, within
Yes,
Hinduism,
they have said so, my lord.
within
At least 3 of,
Hinduism,
yes.
there are many denominations. See, the constitution framers, they were conscious of the fact that there were various schools of thought or philosophies or whatever,
Yes.
which were being propagated through mutts or such institutions,
Lordship.
which ultimately has been given the name of denomination in the constitution,
Yes.
for a lack of a better word.
Quite right, my lord.
Not rigid.
That is
Not so rigid.
no, of course it is not rigid.
The sampradaya is a method of worship or whatever.
Yes, my lord.
It is the philosophy of that denomination which should dominate everything.
Right.
Even temples are aligned to certain mutts.
Correct.
There are temples which are not non-aligned.
They are non-denominational temples.
It's a method of worship or prayer or whatever, or practice of that religion. That is sampradaya.
Correct, my lord.
But denomination is where the framers were aware of the
Yes.
fact that there have been many
Reformers
or whatever you
Yes.
say, the beginners of religion,
Yes.
reformers or initiators of various
Correct.
types of thinking. That is why I said the other day, ekam sat vipraha bahuda vadanti.
Correct.
There are various paths to the
Various-
truth or to the ultimate,
Lordship.
to Brahman.
My lord, that is
That is why they were aware, constitution framers were aware of these various paths.
correct.
So for lack of a better word,
They use
because
denomination.
it's something unique to India,
Yes.
they use the word denomination.
I bow down.
Not make it too rigid.
No, don't make it rigid.
We should give it a flexibility.
Give it a flexibility.
Yes.
But my lord, do not equate it with the whole of the religion.
You don't have ABC, therefore you are not a
No,
denomination.
that ABC was not.
Can't be like that.
No, you're right. You're right, my lord. Use it flexibly, we have no problem. But, my lord, to say that it is the same as religion, my lord, and that all denominations are sections thereof.
That is not the argument.
Correct. No.
This side
Solve
never argued that it is religion.
That's fine.
Anything else? Mr.
Yes. So therefore, my lord, I respectfully submit that so far It is those denominations are those which are at variance with the mainstream to some extent. Hence, just like minorities, my lord, it was felt that they might require protection. That is, my lord, a submission. It is not, my lord, something which follows from the constitution. We are trying to discover, because this religious denomination is a concept, my lord, which is very is not so easy to discover. Three things before I, my lord, come to an end of this, my lord. And even if you take Hindi, the word for religion is dharma in the constitution, and the word for denomination is dharmik sampradaya. They are also not the same thing, even in Hindi.
It is not a very serious issue.
Lordship. Now, before I end, my lord, two things. One is that mere bona fides cannot, my lord, create a religious denomination. That I am bona fide in my belief, therefore it is a denomination, my lord, I don't think. Secondly, my lord, you have to start by identifying the denomination, not the section. Once you have identified the denomination, you will be able to identify the section, not the other way around. Number three, my lord, non-religious denominations cannot happen, my lord, under 26. In fact, my lord, in SP Mittal, it was held that it is not a religious denomination because it's not religious. It's not a religion. But most importantly, my lord, and this is just at a conceptual level, it is a group. So, my lord, it is individuals. It's a collection of rights given to a collection of individuals. It cannot be different from 25(1). Religion in 25(1) and 26(b) must mean the same thing. One final thing, my lord, and I'm going to sit down. Sorry, my lord, I have to give your lordship a little bit on the interplay.
Interplay you have already explained.
Right. Only thing is, I have explained. You are right. So therefore, my lord, we just try to make it graphic. Nowadays, my lord, this is all graphic. My lord, just have a look at one page, because we had this discussion, my lord, your lordship put it to me that there are 4 steps. And I said, my lord, I think there are 5 steps. I have tried to put the 5 steps, my lord, on a sheet of paper. Will you give me this?
We'll consider that.
Yes. Just see, my lord, what Devaru did hold. First of all, it held that the denomination was a religious denomination. The language is not, my lord, I couldn't make it pithy enough to fit there. This is not quite accurate, but the religious denomination is the denomination in question is a religious denomination. It is a denomination. The Gaur Saraswat Brahmins operating out of, my lord, the Mulki Peeth. Step 2, exclusion of non-members is a matter of religion. It was accepted that it is a matter of religion. Had it not been for the legislation, it would have been protected by 26(b). Therefore, 25(2)(b) and 26(b) being on the same level, being co-equals, therefore there is a conflict. Third step is, yes, there is a conflict. Fourth step is, when 2 provisions in a statute come into conflict, the principle of interpretation to be followed is harmonious construction. You must try to give effect to both of them. And the 5th one, which your lordship, my lord, had pointed out, that having given the right of entry, whatever else remains in the right remains. 26(b).
That is why Mr. Gupta said
Proportionality.
This harmonious idea in
Yes.
Devaru
Yes.
is actually a very far-reaching concept, because this crystallizes into the administrative law principle
Of proportionality. Correct, my lord. And there, my lord, it is taken a little more.
Yes.
What it says is that if after seeing that 25
So
to
what
B,
we do whenever we see a legislation under
Yes.
25(b)
yes,
challenged on 26(b) rights,
yes,
we try to see what extent it encroaches.
yes,
We interpret it in a manner
yes,
where the core religious practices
correct,
integral to the religion are protected in one hand.
yes,
At the same time, the intention of the legislature is preserved to the extent it does not overstep.
correct, absolutely, no question.
So if you apply all the principles
today,
of proportionality,
with
that is
our-
how
yes.
the harmonious construction
So, my lord,
evolved.
I bow down, my lord. In today's language,
It will
the
be
proportionality principle will come in.
It is like something like a Lakshman Rekha,
Yes, correct. my lord.
And this is,
of-
and
even by the
maybe
legislature.
that is why the integrality issue
Yes.
is so relevant
Yes,
when we test constitutionality
Lordship.
and not the interplay of 26B vis-a-vis 21 or 19.
Those are different, my lord.
That's all, Mr. Gupta.
Just one more statement. A, B, and C of 26(1) are absolute rights, your lordship has said. B, you have always said that it is an absolute right. Now, the group should not have an absolute right which is greater than the individual.
Except that subject to 25.
Lordship.
We understand, we understand. Okay.
One more thing, my lord, C is a fundamental right to property, which was all right when it was framed because 19(1)(f) gave it to everybody.
Subject to law.
But now 19(1)(f) is gone. Denominations will be the only people in this country who will have a right of property. Subject to what fell from your lordship, that this may also be subject to law,
Yes.
as D is. Well, I noted
If
that.
you give a relook as C and D
Well, I-
will be covered by the word in accordance with.
Very good. Well, if it's possible to.
Mr. Gupta, see the two capsules.
Yes.
One is very much associated with the principles and religious edict, that is to
Correct.
establish and
And-
administer an
and
institution
Yes.
and manage the affairs. The others is
Property.
slightly secular,
Yes.
but definitely the crucible in which the institution
Will
will be housed.
Right, correct.
So that's why they are in the C and D category.
Lordship.
So we take it from your argument,
Yes.
subject to law means
Yes.
subject to 25.
No, subject to law means the law of acquisition, my lord, here.
Law of acquisition, and then it'll also come under say to 25 also.
Because, my lord, D expressly says administered property subject to law.
Subject to general law, any other,
General.
law means any other law.
General. Yes. My lord, before I end, my lord, just
It's
one
only
sentence.
when
Hmm.
manage and administer an institution like what Dr. Singhvi argued about the Parasnath
Yes.
Hill
Yes,
or the Nyamgiri Hills for
Yes.
tribals,
yes.
where
The whole hill.
C relates to A of such importance to the
Yes,
religious
correct.
denomination,
Correct.
it becomes inviolable.
Yes, my lord. That
Even
is,
the acquisition.
that
laws
is
have
what
to be practiced.
Ismail Faruqi also says. Because there, my lord, the acquisition of that mosque
Mosque.
area and putting it under a receiver, statutory receiver, was held to be valid because that particular mosque was not an essential mosque for the purpose of the religion. So therefore, my lord, if, of course, my lord, it's a doomsday scenario. If all that has been argued on the other side is to be accepted, then we will be back in the dark days. Because, my lord, all institutions will be covered by Article 26. All institutions covered by Article 26 will be private. Institutions which are private cannot be touched by 25(2)(b). So, my lord,
No,
temple entry laws will not be possible.
denomination temples are not private. They're not at all private.
No, that's all. I've given it to them on the chart.
That Mr. Gopal Subramaniam, on the query, he said, all denominations will not be considered as public. So we have our own reservation on this,
No.
but
I
we
don't-
even went to the extent of saying.
No, my lord, the judgments say that you will
It
check the facts of the
That's
particular.
correct, right.
Private temples are essentially.
That's a better way to go about it. Yes.
Indeed, my lord, family temples are there, no problem.
Family
You see,
temples.
my lord, in family temples, my lord, if you want to make it private, you cannot open yourself to donations from all and sundry.
They may not want to.
They may not want to, but if they want, then it becomes a public temple. My lord, I'm deeply obliged.
Thank you, Mr. Gupta. Thank you.
My lord, before I stop, I have a request from the junior bar. I want to bring it to your lordship's attention.
We want to accommodate
No,
everyone.
my lord. They have gone to the painstaking extent of calculating who has argued for how long. My lord, the total time taken on that side is 35 hours, and on our side so far, my lord, is 15 hours. So, my lord, they have requested.
Not 15 hours, I think there is a wrong calculation.
All-
Persons who have
It is up
argued
to
for the
staff,
other
we
side
have
have
to get
argued
more
as
time.
if they are
No,
arguing for.
what I'm saying is very simple. My lord, please consider, my lord, they have asked me to put it before your lordship. Please consider giving them, my
We
lord,
will
and
try to accommodate, we can sit for 1 hour more today, but we have to conclude this side.
lordship.
Yes, Mr. Ansari, please in 15 minutes or so.
15 minutes, I will not be able to, but I will be as short as possible. my lord.
You are always very
I
to
understand.
the
my lord.
point straight. hit and-
I will be as short as possible, my lord. My submissions are, my lord, in volume 2.2.
If I may be excused.
And I joined the request of my learned friend, Mr. Rajiv Gupta, my lord. Maybe, my lord, if your lordship want to accommodate, they can be accommodated before me also, my lord. I have no dispute. 15, 20 minutes, 3 or 4 of them, my lord, because they should not have a grievance that they are not heard.
Yes, yes, yes.
Lord, my submissions are in volume 2.2. I'm in Sabrimala case for 3 ladies, my lord. One, a woman from Karnataka, who went, my lord, after the judgment along with the family after Varnam, etc.
Whosoever may
But then,
you can read.
no, because your lordships have asked for about this, my lord. And she was not allowed to rest of the family went, my lord. One is a professor in Delhi University and one is a practicing advocate of this honorable court. My lord, I have 3 or 4 submissions broadly, my lord. First, my lord, I feel it privileged, my lord. I may if addressing, my lord, 9 plus 4 judges from Bhutan. I thought that I'm addressing 13 of your lordships, my lord, which is the highest number of judges ever constituted. Very well. Lord, may I start with saying, my lord, what Granville Yastin say that the constitutional mandate is the replacement of fundamental wrong with fundamental rights. That's the test, my lord, which your lordships have. Now, my lord, argument of the other side is that 26 is a standalone legal provision and it cannot be shackled or inhibited by the other provisions. My lord, I highly dispute it, my lord, and I'll make it good that it's not. My lord, as Mr. Khambata has said, that Article 25(1) is the genesis, my lord, and 25 and 26 is the species or facet or dimension of Article 25(1). Now, 25(2) is totally different. Now, if your lordship see 25(2), 25(2) says, my lord, nothing in this article shall affect the operation of any law preventing from the state. What it would include it, my lord, if 26 is a part of 25(1), then a law made under 25(2), which is nothing in this article shall affect the operation of any law, shall affect the existing law or prevent the state from making any law. My submission is, my lord, the state can make a law which will maybe violative of 25(1) of its own. And if 26 is a manifestation of 25(1), then, my lord, definitely law can be made violation of 26 also. 25(2) law will override, my lord, a law made under 25(1) or 26(2), my lord. That's my respectful submission. And such law can be, my lord, for social welfare or for throwing open the religious institution of public character to anyone. Now, if a social welfare legislation is made, and that is, my lord, challenge on the ground that it violates 26. Lord, that cannot stand scrutiny. The reason is, my lord, 26 is part of 25(1) and 26 to 25(2) controls it. My lord. Another submission of mine is, my lord, that 26, if your lordship see, my lord, 26 does not say with notwithstanding anything, my lord. There are 30, if your lordship see, my lord, para 5 of my proposed submissions, my lord, in my submissions, there are 36 such provisions in the Constitution. If your lordship kindly permit me to show page 7 of my submissions, volume 2.2, page 7, running page 11.
Yes.
I have catalogued them. There are 36 provisions in the Constitution which say notwithstanding anything in the Constitution, which 26 does not imply, which includes, my lord, Article 35, which says notwithstanding anything. And, my lord, I have given the list in Annexure 1, at page 36 of this. For example, my lord, Article 258(8) says, the power of the president with the consent of the may entrust the executive power of the union to the state, notwithstanding anything in the Constitution. 258(a) says the reverse, notwithstanding in the Constitution. There is no such provision in Article 26. So it cannot claim a supremacy right, my lord, over other provisions of the Constitution. There are 24 provisions, my lord, which says notwithstanding anything in this part of the Constitution, which is also not there in Article 26. So it does not, my lord, if your lordship see, my lord, my submissions in para 6, which says there are 26 provisions which say notwithstanding any part. For example, my lord,
Article 34 and
34, 116, 249, and my lord, I have given the list at Annexure B, my lord, page 51. And there are, my lord, 25 provisions which says notwithstanding in particular article. For example, my lord, Article 6, 7 and 8 says notwithstanding Article 5. Article 35 capital A says notwithstanding, my lord, Article 31B says notwithstanding Article 13. There are so many, it cannot be said that Article 25 is not subject to the rigor of other provisions of the Constitution as is sought to be made, my lord. That is my second limb of argument. Third is, my lord, argument is made at 25(2)(b), any class or citizens. Now, would your lordship permit me to show that the draft constitution had any class or section of Hindus, which Durga Bai, in my written submissions, my lord, if a lot, you have given the hard copies also, my lord. Durga Bai in the Constituent Assembly debate say it's a narrower provision. The provision should be as wide as possible and suggested that it should be made that all class and citizen instead of any class or citizen. That was accepted and the amendment was moved, was my lord passed with that provision. My only anxiety is to show that the argument is made that any class or section does not include women category on the basis of sex. This is not correct, my lord, because the Durga Bai was very categorical that we must give wider meaning to this expression. So the smaller meaning is the narrower meaning would be any class or sections of Hindus which should be modified or amended, substituted as all class and citizen. This your lordship will get at page 71, my lord, of this compilation. At the end of it, that part of the debate I have quoted, and Dr. Ambedkar agreed with it. May I just read that part of it, my lord, if your lordship permit me. Page 71 is the part of the Constituent Assembly debate. Sir, I beg to move the following amendment. In clause B of clause 2 of Article 19, any class of citizen, the word all class and citizen be substituted. My amendment is accepted. And the reason is given, sir. My view towards the bottom of the page. My view, the clause as it stands is restricted in its scope. The object of my amendment is to secure the benefit in a wider way to make it applicable to all class and citizens. Though we are not able to make sweeping reform or a mere comprehensive reform in this direction, I feel no distinction of any kind should be made between one class of Hindus and another. Now, with regard to Hindu religion institutions of public character, we are all aware that there are various classes of the institutions such as temples, religious mosques, educational institutions or partsalas conducted by this sense of institution attached to this institution. So far temples are concerned, I am sure all of us are aware that almost all the provinces, including some states, have already passed law throwing upon temples to all classes of citizens, but I'm equally concerned about Patsala. So, my lord, the Constituent Assembly makers by that time, my lord, thought that temples are open to all class, including all women, my lord, of all without any discrimination. That is the idea behind the amendment, my lord, and that was passed by the Constituent Assembly. Now, my lord, I come to, my lord, a very touchy subject.
Yes, please.
Of morality, my lord. Now, morality, my lord, Article 25 and 26 both says subject to morality. The concept morality has not been defined, my lord, in any of the statutes. Now, would your lordship permit me to place, my lord, 2 pages of my written submissions, page 24 and 25 on this, my lord. PDF 28, internal page, my lord, red color page 28, and the internal page would be 24.
Paragraph 22.
Para 27 to 32, my lord.
That's it.
It is submitted that the expression morality covers a wide range of negative and positive obligations of persons in a civilized society. The word morality has to be ascertained in the context in which it is used. There is no statutory defined meaning of the expression morality. Dictionary meaning is the normatively to refer a conduct that is in a given condition that would be endorsed by all rational people. Merriam Dictionary says conformity to the ideals of human right conduct. Cambridge Dictionary says a set of personal or social standard for good or bad behavior. Oxford Dictionary says principles relating to right and wrong or good or bad behavior, the degree of which something is right and wrong. Lord, what is one of the principles, if your lordship kindly come to para 28, the expression morality can be viewed from different lenses. various jurists and philosophers have recognized harm principle as one of the principles of morality. The principle means that your right to swing your fist hand ends when my nose begins. In other words, people should be free to act as they wish so long as their actions do not cause harm to others. The harm principle is the central to the political philosophy liberalism, which values individual rights and personal liberty. According to John Stuart Mill, the only purpose for which power can be rightfully exercised over any other member in a civilized community against his will is to prevent harm to others. In the present context, it is submitted that if the women enter temple, it doesn't physically hurt anyone. It does not take away men's right to pray. It does not stop the temple from functioning. By saying women cannot enter the room sends us the loud message to the society that women are impure and lesser humans than men. This message is a form of harm because it treats women like second-class citizens in their own country. Sometimes a big group of people wants to keep tradition alive, and it is unfair to smaller group. If the group tradition is based on we have always done this way, but it treats it individually fairly, the court must step in to protect the individual right from being crushed by the other group's power. It is submitted that the jurisprudence is a tool for social engineering. In India, the constitution is a transformative and not a static document. Lord, this is a document. Morality is envisaged in Article 25 and 26 is not the morality of a particular sect or social morality or social morality of the majority. It is the constitutional morality. It involves the commitment to the values of justice, liberty, and equality. Any custom that excludes women based on biological factor is jurisprudentially unsound, as it contradicts the primary moral code of the land, which is the constitution. In a secular democracy, the state and the court cannot enforce religious purity norms if they violate the civil rights of a large group of people. While a religious denomination may view menstruation as a lens of real impurity, theoretical morality, the law must view it through the lens of biological reality, secular jurisprudence. Jurisprudence demands that a legal restriction must have a rational nexus to a legitimate state claim. Excluding women to prevent the calibrate collector of a deity is theological argument and not a legal one, and cannot override the fundamental right to worship. It is submitted that the morality is a matter of subjective interpretation. There is no reason to exclude constitutional morality from the meaning of the word morality, not to restrict the principles of constitutional morality to administrative functioning. The principle, etc. Then I have quoted it, my lord.
Yes.
I need not go to that.
Yes.
Now, my lord, one more important, which is, my lord, is regarding, lordship would permit me to show the paragraph 22 and 23, which is, my lord, page 20, PDF 24. My lord, in the context of Sabrimala temple, your lordships are not adjudicating it, but some facts are necessary. The whole basis of debarring women, if they are of a menstrual age, the lordship would consider, my lord, me as a 10-year-old girl. I'm going with a family, my lord, to the temple with entire Vratam, etc. I have a very, my lord, since birth, I have heard about. No, my lord, regarding menstruation, it's a taboo, my lord, which is Justice Mahadevan has said in a recent judgment, my lord. I have quoted Jaya Thakur here, which says the society's responsibility to remove this taboo or a stigma or a social cultural restrictions on that, my lord. If I can read para 22 and 23, my lord, if your lordship permit me that.
To consider it a taboo, it is a taboo. If you don't consider it a taboo, it is.
No, my lord, my taboo is my
question is how you view it. How
yes,
a
lord.
devotee would view
Yes,
it, not how a non-devotee would view it.
my lord, I'm a devotee, my lord. I'm a devotee. Some people say it's a taboo. It's a duty of the.
Don't go by what others say. Go by your conscience.
No, conscience, my lord. My conscience does not treat it as a taboo. My conscience does not treat it as a stigma. Now, that's why, my lord, your lordship's court has to go, my lord, and I'll read the 2 paragraphs of that judgment, my lord. It is submitted that debarring women of menstrual age from visiting a temple of their belief and choice is against the public policy of India. Any policy or practice.
Other side's argument is, as Mr. Says put it, it is not a taboo, and they say there is no restriction for other temples to go. These are all other things. We are going to the.
What I'm saying, my lord, it's just if in a particular case it comes under the category of social reform.
We have to decide that. Please leave it at that.
Yeah, we are considering this aspect in the context of whether it is a religious practice.
My lord, what I'm saying, even if it is a religious practice, if a social reform required, a law is made under 25(2)(b). If a law is made under 25(2)(b), that law cannot be struck down on the grounds of, my lord, its religious practice, be it essential,
Very
be it
well.
rational, or be it whatever
Very
it
well.
is.
Got it.
Because 26(2)(b overrides, my lord, 25(1) as well as 26, my lord.
State make a law. Then
The state makes a law, my lord, it cannot, that's what I'm saying.
Today, the state has not made a law.
No, state in the Kerala Act,
State, on the other hand, has recognized the ban.
no, with great amount of respect, my lord, the state makes a law.
Court which has struck
No,
down.
what the state makes a law. In that law, my lord, if it is, my lord, let us proceed on the basis, the state makes a law. Entry of every woman of every age is allowed in a temple. Can that law be, my lord, struck down on the basis that it violates 26(2), 26(b)?
Yeah, we can't answer this question.
You can't
on
answer it
hypothetical.
like that.
All
It
that,
all depends
my
on.
lord, all that,
Going to the larger issue.
no, all that I'm requesting your lordship to say,
Because
if your lordships comes to the view,
Courts would be extremely reluctant
I'm not,
to pronounce a judgment in future.
Yes.
no, all that I'm
That-
saying,
but-
my lord,
but that
all that
if
I'm
it
requesting
were to
9
be
of
a
your
law, then
lordships.
we will take a view like
No, no,
this.
all that I'm requesting 9 of your lordships, if in a given case, if a social welfare legislation is made by the state, that legislation has to be upheld, my lord, and cannot be struck down on the ground of any religious practice.
If the people of this country,
Yes,
through their elected representatives,
my lord,
raise a common voice
my,
that if this issue requires social reforms,
please, your lordship,
probably the court will accept it as a social reform.
my lord,
But if it is against the wish and will of the people,
yes.
something is thrusted upon them or as a rule of gagging them, maybe the court will
No,
interfere. with-
what
It all depends upon.
And it all depends on the facts of the case. My lord, what I am requesting your lordships to hold on a bench of 9 judges is, if there is a social reform legislation by the state under 25(2)(b, that will prevail and that cannot be struck down on the ground of violation of 26(b). That is my submission, my lord. And this court's responsibility also comes, my lord, to remove the taboo and the socio-cultural restrictions, my lord. And your lordship judgment in Jaya Thakur, my lord, Justice.
The existence of a social reform will clinch the issue. That's all you are saying.
And my lord, because, my lord,
Because state decides it.
there's one more.
There exists a social reform.
Yes.
Do not test it with on the basis of a religious right.
Please,
You
my
understand,
lord, only one more thing, my lord. Social reform and morality, because, my lord, 26, even alternative argument, 26 is subject to morality. Now, social reform is a part of morality. Now, if there is a social reform, you cannot say it's an immoral act. Social reform, my lord, would be at par with morality. If 26 is by of its own operation is subject to morality, then it is subject to social reform also, my lord. Because opposing a social reform is an immoral act. That's my respectful submission, my lord.
There is right to conscience and religion also.
Yeah, that is, my lord, why? That is why 25(2) says nothing in this article will affect the power of the state to make a law. Similarly, my lord, this will override, that my preliminary first submission was, this will override also come within 26 also, will come within 25(1). If that argument of Mr. Khambata is accepted and which I endorse, my lord, which I adopted as respectfully for your lordship's kind consideration, my lord.
Yes.
Lordship would give me a minute, my lord. Lord, regarding the scope of judicial review, Coelho, etc., my lord, the lordship has not
Thoroughly argued at.
seriously gone into it, my lord.
In fact, you have covered all your points in the note. The main thing which you have, Mr. Ansaria, the new thing which you have really argued is based upon the categorization of the expressions used in different provisions of the Constitution.
Please, your lordship.
With respect to non-abstante clause,
My lord.
where limited non-abstante clause,
My lord.
non-abstante clause.
My lord.
That part we appreciate, that is the
yeah.
new point you have developed.
Please, your lordship.
The second, of course, is
It's the social reform part of it. Social reform part of it. And thirdly, my lord, any class.
Take care of your note.
My lord, yes. Thirdly, my lord, any classification, your lordship has said right from Annual Sarkar, my lord, it has to meet the twin test, my lord. If it does not meet the twin test, excluding women of a particular age my lord, that your lordship will decide in Supreme Law. But and a principal lordship would say, my lord, it has to meet the twin test, my lord, of Article 14 also for classification of debarring any woman of any age, my lord, which must have a rational nexus with that, my lord. That's my lord, there is only also a list of, in my written submissions, I have annexed a list of religious institutions, my lord, where except in 5 cases where the learned Solicitor General has pointed out that there are restrictions of women or men, etc. All that, if your lordship just note that, my lord, paragraph 25, page 25, yes, page 26 PDF, para 20, I'm so sorry, my lord, page 25 PDF, para 25, page 25, both. That a list of 36 well-known religious places like temples, mosques, church, Gurdwara, Jain temples have been tabulated showing restrictions imposed by them. It is submitted the
There are and there might be hundreds and thousands of religious places.
Yes.
Because we, while sitting here,
No,
or maybe that
we
of
do
this
not,
side,
what,
will not be able to have a complete list.
yes, will, I not, well,
Men may not be permitted, women may not be permitted, the women in a particular age might not be permitted, women in a particular hours may not be permitted.
no, yes.
Men may not be, all these things.
My lord, what I'm saying, my
Probably-
lord, there are no temples, my lord, where women of this particular age are restricted. And the 5 examples which are given, my lord, I have given the details also in para 26, that there are restrictions on particular days or particular time. Not that the throughout 50, 40 years of my prime life, I cannot go to a deity to whom I revere and have a devotional as a family.
Temple, Ayyappa temple anywhere else in the India or in
Lord,
the
if-
world,
my
they
lord,
can
I have
go.
a devotion, my entire family is devoted to that. Since birth, I have a, my lord, faith to go, my lord. It's my
No,
lifetime.
don't worry, you have the blessings of Ayyappa.
Wait till 50.
No, my lord, that's all the more reason, my lord, that if why so it is not an essential religious practice of Lord Ayyappa temple.
Faith, then they will wait till 50 or
No, my lord,
whatever age.
I have faith. I can, my lord, definitely raise my my lord, concern about the social reform which is required, my lord. That's my respectful submission.
Thank you. Thank you, Mr.
Very well.
Thank you.
Please, your lordship. I'm extremely grateful to you, lord. Please.
Yes, Mr. Giri.
And just 1 second. Let me approach.
No, you can start from there on.
I know I have a loud voice. My lords, I
Not in the code. In the TV debate, yes.
I
Not
have-
loud. You have persuasive voice.
Please, my lords. My lords, I appear in IS 78583 of 2026. My lords, I appear on behalf of the rationalists. The rationalist in this case, my lords, Dr. Hamid Dabolkar and Ms. Jadhav, they are members of a society called the Maharashtra Andhashraddha Nirmulan Samiti. Your lordships may remember that Hamid Dabolkar's father, Dr. Narendra Dabolkar, was assassinated in 2013. It was followed by the murders of Comrade Pansare, Professor Kalburgi, and Gauri Lankesh. My lords, it is our respectful submission that there are several accretions to religion or which claim a religious descent, which have been exploited and which should in no way receive the protective cover of religion. My lords, this is one part of it. Lords, on the other part of it, speaking for myself, my lords, I stand in the proud tradition of somebody from Udupi who is from where both Shirur Mutt and Venkatramana Devru came. Justice Arvind Kumar has a slight smile on that, my lords. It's from that district. I also come from the tradition of Mr. B.N. Rao and B. Shiva Rao, who helped frame the Constitution. My lords, speaking for a rationalist or a rationalist perspective, what is it? My lords, we rationalists are not necessarily atheists. We are people who say that, look, everything, including religion, has to go through the filter of reason. The rationalist principle is also relevant with regard to the actual constitutional history and the history of these two provisions. It is my respectful submission, my lords, that one should not take just these two provisions alone. Please bear in mind the history with and the historical moment in which this constitution was forged. My lords, we are a deeply religious, ritualistic country. We are a country that suffered a partition because we could not accommodate certain religious identities. We are also a country whose constitution was written not only in the backdrop of a struggle against imperialism, but also a social struggle among ourselves. Today, my lords, we are on the 101st anniversary almost of where the story begins in Kerala, not Sabrimala. In 1925, there was the Vaikom Temple Satyagraha. The Vaikom Temple is south of Cochin. Not only could people not enter the temple, but even the roads around the temple were not accessible by not only the depressed classes, but also certain other castes. The Satyagraha against that was settled by the Mahatma, but from the Satyagraha came, among the people who participated in the Satyagraha was Periyar. And Periyar then goes on later to say that there is no God. In that Satyagraha also was Narayan Guru, who was quite old at that point of time. And he said that the compromise which Gandhiji came out with was not acceptable to him, because the compromise was that new roads would be built around the temple. Everybody could access those roads. And the Queen Regent of that day said, no, this one road on the east, that will still remain closed. It took about 11 years thereafter, till 1936, when a new when a new Maharaja came in, and the Maharaja then said, on the advice of his Diwan, Sir C.P. Ramaswamy Iyer, Mr. Aryama Sundaram's grandfather, said that everybody could enter. And once that temple entry proclamation from the Maharaja came, the Maharaja of the neighboring state excommunicated almost everybody who was from Cochin. While this Satyagraha went on, after this Satyagraha, shortly thereafter, came the Mahar Satyagraha, which Dr. Ambedkar launched. Dr. Ambedkar wanted to drink water from a public tank. That was not allowed. And at that point of time, once the tank Satyagraha happened, there were criminal cases which took nearly a decade thereafter till 1937 to solve. While the case was pending, Dr. Ambedkar's disciples launched yet another temple of Satyagraha. That was the Nasik Kalaram Temple Satyagraha. The Nasik Satyagraha and the Dandi March. I'm sorry, my lord.
Stopping you just for a moment.
Please, my lord.
Probably before Mahatma Gandhiji professed non-violent agitation, it was in Kalaram Temple Satyagraha. Baba Sahib Ambedkar gave a call to all his disciples not to follow the path of any violence.
Absolutely, my lord. I'm grateful.
It was the first non-violent agitation.
Absolutely, my lord.
I mean, due credit to Gandhiji, but probably it was the first non-violent agitation on a call given by Dr. Babasaheb Ambedkar.
I am grateful, my lords. And Dr. Ambedkar's disciples who launched that satyagraha, prominent among them were the women. It was the women of Nasik, the depressed classes women of Nasik, who also had those particular jathas or whatever to claim entry. My lords, it is in this context of temple entry and social reform that between 46 and 49, when a constitution was being framed, please look at the historical backdrop. The historical backdrop was this, that the world had seen what wrong religion could do. We had partition violence, we had the Jewish Holocaust, we had the murder of the Mahatma. So when we drew up our constitution, we sort of said that, look, these are paths where extremism does not work. We drew up a constitution, my lords, which a professor, Hannah Lerner, said in a book called Constitutions for Deeply Divided Societies, my lords, making constitutions in deeply divided societies. She said that what was done was a process of constitutional incrementalism. You do not look for a huge revelation coming down from the high. What you do is you embrace competing visions of the state, thus representing the identity of the people as it really was at the time of drafting. In other words, a divided identity. The incrementalist constitutional toolbox included strategies as avoiding clear-cut decisions, using ambiguous legal language, and inserting internally contradictory provisions into the Constitution. For example, cow slaughter. There were people in the Constituent Assembly who said, give us a clear line. Is cow slaughter to be, are we to eat cows or not? Are we to slaughter them or not? There were others who said, no, we can eat anything. So therefore, it was put in there in the directive principles as in Dr. Ambedkar's quest for scientific development of milch cattle, etc., etc. And there it was put in there. So this incremental approach came even in 25 and 26. What is it that these two articles have done? These two articles, my lords, in my respectful submission, if your lordship gets back to the text of the article, firstly says that everybody is equally entitled. So everybody possesses the freedom of conscience. That's the first thing. Whatever your conscience says. And the right to freely profess, practice, and propagate religion. Now, please note, there is a significant omission here. The significant omission is of a pronoun. It doesn't say their religion. It doesn't say the religion of their birth. It doesn't say the religion of their choice. It says religion. You can, theoretically, wake up a Hindu, be a Muslim at lunch, and be a Christian at night. Whatever is your conscience, whatever is your religion, you are free to do that. However, it is subject to public order, morality, health, etc., etc. Now, my lords, then this is your individual right. What happens if you bunch together as a collective? People who sit together, who worship in the same way, they can form a denomination. There will be people who, like Dr. Dhawan, are Arya Samajis. That was a rationalist principle when Mool Shankar of Gujarat saw rats eating the prasad on the shivling. He said, why should we worship idols? We shall go back to the book and we shall have only Vedic rites. And that's how one form or one denomination came to be formed. But denominational rights, my lords, are only a collective. A denomination does not necessarily have a juristic entity. It is not as if any greater right gets conferred, except what everybody among their members has. And that is why, my lords, when they spoke in 25, that it would be subject to the other articles of the fundamental rights and to the other provisions of this part, then you take that, you collect, you congregate. What else do you get? You get to establish and maintain institutions for religious purposes, to own and acquire immovable property, to administer such property in accordance with law, and to manage its own affairs in matters of religion. Now, this denominational right, who do you claim it against? It is not only that you claim it against the rest of the world, but you also claim it against orthodoxy of your own religion. It is, if I could illustrate, my lords, if your religious doctrine, with respect, my lords, to I don't intend to denigrate any of this one, but supposing your religion says that there is only one God and one prophet, but there is a denomination which says, yes, there is God, there is the prophet, but there is a subsequent prophet. Then, with regard to that, with regard to the orthodoxy of your religion, you can manage your own affairs. That is possibly one possible interpretation, my lords. My lords, I have drawn some supplementary submissions, my lords. May I just hand them over? Just hand over. The thickness is only the annexures, and I'll quickly run through them. So please don't. Okay? No, okay, no.
Mr. Hegde,
Please, my lords.
if you understood you correctly, 25(1), you are trying to interpret it that you have the right to profess means in the morning you say that I am a Christian, in the afternoon you can say I am a Muslim, and then in the evening you can say.
Please,
That is the understanding?
yes, my lord.
Then read it once again with me.
Please, my lords.
Subject to public order, morality and health, and to the other provisions of this part,
Please, my lords.
all persons are equally entitled to freedom of conscience. That is one part.
Please,
Freedom of conscience is very at the uppermost. And the right freely to profess, practice and propagate. If we give that interpretation which you are trying to canvass, then it means that I am a Muslim in the morning. I have my, I profess that I am a Muslim. But practice, I will go to a temple. I would say I will practice my Muslim belief in that. If we read it, because this has to be profess, practice and propagate has to be a common religion. Otherwise it will lead to absurdity. If you say I will profess that no, I am a Muslim, but I will go to a temple and I will practice the tenets of a Muslim and propagate that Islam there, then it is absurdity. You can't read that it is two separate, three separate. It has to be read in a chain. It has to be profess, practice and propagate. That has to be one composite. You cannot move around.
Practice, profess and propagate religion,
You're
not
right, but
necessarily your religion.
But right, but
is
if you
just
give that
any religion.
no, but if you get that interpretation that you can propagate or practice, that means I will profess I am a Muslim, but I will go and practice. Because I am a Muslim, I profess. I'll go and practice my type of religion, my type of worship in a temple. If that interpretation, then it's absurdity. How can
Please,
you
Mal.
read this process? You
Please, my lords,
you
there,
take a very different level.
there, you can profess, practice and propagate your religion in its religion in its appropriate place of worship.
Then this has to be read in harmony.
Please, my lords,
But
there,
when you profess, that's not-
let's keep the place of worship out. Let's
But
keep the place
practice.
of worship out.
No, no,
Let's
that is
keep the place,
practice.
just to
That is
illustrate.
associated with practice.
Just to illustrate, let's keep the place of worship entirely out. In this courtroom, in the morning, I can proclaim that I'm a Muslim. In the afternoon, I can say that Christ is my savior. And in the evening, I can say that the Bhagavad Gita is the only thing. They, in a,
Mr. Hegde, nobody is disputing that. You do whatever you want.
please, my
Who's
lord,
stopping you?
conscience.
So long as you
Yes.
don't trouble the others.
Yes, my lord. My lord was trying to tie me down to a particular geography.
Don't go into the Muslim behaving as if you are a Christian. So go into your temple thinking you are.
Yes, when you go anywhere.
They are saying.
Please, my lord.
You-
When you go anywhere.
As nobody stops your
Please, my
individual belief, right to practice something, don't get into others. That's all.
My lord.
Eclectic in
We can be eclectic and
Please don't take to the practice.
please, my lord, the rationalist view would be maintain a respectful distance. When you go to any place of worship, you go by the tenor of that place. I was in a cathedral in Russia. It was cold. I had a cap on. Now, having a cap on in a religious place is correct in India, or covering your head is correct in India. But in Russia, no. As a sign of respect, you have to take off your hat. So when you approach a religious place, my lords, that is rationality. Yeah, but please, my lords, may I just, I have handed over these submissions, and my lords, I have put out the details of the interveners.
Yes,
And-
you have already explained to us.
Please, my lords, to just the first paragraph, the second paragraph in the preliminary. These submissions, page 1, my lords, these submissions are made with 3 convictions. First, the Constitution is supreme. Second, its text is the court's only safe guide. Third, its commands are not displaced by custom, however ancient, or by claim, however earnest. The authority of this court, I'm sorry, my lords, the first page. The authority of this court rests on the Constitution. The authority of the Constitution rests on its text. These submissions return again and again to the text. My lords, I have thereafter, I have defined rationalists, my lords. And now if I come to page 3.
Yes.
Constitutional recognition of rationalism and rationalists. The Constitution recognizes the rationalist standpoint in 5 distinct places. The preamble secures to all citizens liberty of thought, expression, belief, faith, and worship. The order of these words is not accidental. Thought, comes first. Article 25(1) guarantees freedom of conscience. Conscience is a faculty of the individual. The article protects the conscience that says no to belief equally with the conscience that says yes. The right to disbelieve is contained in the right to believe. Article 28 forbids religious institution in wholly state-funded schools and forbids compelling any pupil in a state-recognized institution to take part in religious instruction or worship. Article 28, my lords, can be read as a charter for the rationalist child. Article 51AH makes it the duty of every citizen to develop the scientific temper, humanism, and the spirit of inquiry and reform. This duty is unique to our constitution. No other constitution in the world names scientific temper as a civic duty. Article 25(2)(b) permits the state to throw open Hindu religious institutions of a public character to all classes and sections of Hindus. The provision itself is a rationalist provision. It places reform inside the constitutional scheme, then outside it. Then, my lords, I would not need to read the other bits, my lords. And then, if your lordship comes to page 4, Articles 25 and 26 of the Constitution form an integrated scheme of religious freedom and must be read together. It has the following features. The Constitution protects, my Lady Justice Nagaratna has got it?
Yes.
Please, my lords. And must be read together. It has the following features. The Constitution protects belief absolutely. It cannot prescribe what a person may think or in whom he may have faith. The Constitution protects practice conditionally. Practice is subject to public order, morality, and health. Individual practice is also subject to the other provisions of its part. That's 25(1). The Constitution protects religious autonomy in matters that are intrinsically religious, doctrine, rite, ceremony, but not in matters that are secular though associated with religion. The Constitution arms the state with reform power, especially over Hindu religious institutions of a public character. Then the Constitution does not establish a religion. Article 13 supplies the bridge between religion and constitutional discipline. It declares void any law in force, including custom or usage having in the territory of India the force of law. To the extent of inconsistency with Part 3, the religion that the Constitution protects is therefore the religion that has passed through the filter of Part 3. A custom that fails the filter does not become protected by being old. That, my lords, is the heart of the submission. Custom as a source of law, custom as enforced by law. Ultimately, what did your lordships do in the 5 judges? There was a rule which was actually drawn up. That was man-made law. Your lordship said that in this constitutional scheme, that man-made law cannot survive. And I'm making a distinction. There may be customs, there may be sampradayas. There will be acts of individual discipline, like that hat example that I gave your lordships. People, and most people, will normally follow that. It is where there is an assertion with the force of law which runs contrary to the constitutional scheme, it is then that the courts step in, saying, no, you don't have that power. You cannot by law say, by man-made law, say that women will have to stay out of this institution for a period of 40 years. If instead there had been a discipline which said, that on those specific days, please don't come. It's not a total exclusion. An exclusion which is so whole that it denies the right of the worshipper will fall afoul of the Constitution. That is exactly what Venkatramana Devaru was. Venkatramana Devaru, incidentally, my lords, refers to the deity himself. It was Lord Venkatramana who came before your lordships. And the traditions of the temple were that one particular sect of people had been called in antiquity by the Raja of that place to come and settle in that place and build a temple. With the passage of time, everybody worshipped in the temple. The question is then, we have this denomination which established the temple. We have the right to manage our own affairs. Is our right to be totally nugatory? Totally negated, that there are times when we exclusively worship. So that's why this court said, let's harmonize, where your right does not totally eat away the other right of entry, you are entitled to it. But let us assume that the god Saraswat Brahmins of Mulki said that, notwithstanding the fact that it is now a public temple, it is only us who can worship within the temple courtyard. Others stay out, stay at a respectful distance. Then would it fall afoul of the Constitution? It's my respectful submission that it is then that temple entry has to be given full play. I thought about this matter, my lords, and it is my respectful submission that ultimately in matters of rite, ritual, agamas or whatever, within the sanctum sanctorum, it may have full play. But beyond that, it cannot be. My lords, the principle again comes from my hometown of Udupi. In Udupi, my lords, the temple was forbidden to a lower caste worshipper. Kanakadasa of Udupi came in and was not allowed in. Your lordship knows that most Hindu temples, the idol looks eastward. When Kanakadasa was not allowed in, he stayed outside, continued to write bhajans, continued to write holy songs, till the idol itself turned around, broke open the back gate, and gave him darshan. The moral I derive from that is that God does not discriminate, man does. And the same legend goes to the east. Your lordship will remember in the Jagannath temple, Bhakta Salveg was denied entry to see the Lord. Bhakta Salveg stood outside. When the Lord came out for the Rath Yatra, the Rath did not move until Bhakta Salveg was given darshan. In my lord's example of the Varkaris, to the Pandharpur temple, people of all kinds go during the harvest season. But some people were only prohibited from entry. They could go to the statue of Chokamela, to the grave of Chokamela. Chokamela was, my lord, somebody who had been denied entry, and his very bones, when he died, kept saying Vithala, Vithala.
Now, if you're referring to Chokamela, verse Chokhamela said, because he was born in a community. And the word goes that Umbaratasi kaise siu ami jati hina, rupa tujhe kaise pahu tyatahi ami hina. And this was because the entry was prohibited. And this was in English expressed by Chokhamela.
Please, my lords. And to come back to the modern age, my lords, when Mrs. Ambedkar, the first, was very ill, she wanted to go to Pandharpur. Dr. Ambedkar said, no, I'll build you a new Pandharpur. Justice Varle will tell you that at that stage when she was unwell, she came to his family. She stayed with his family. My lords, discrimination has not gone away. Today we have the Bhima Grantha, which is the Constitution of India. It is in that we place our hopes. And my lords, if I can come back to comparing at page 6, comparing collective protections and the sum of individual rights.
When the Lord appeared.
Please, please.
Common factor in all these instances which you quoted.
Please, my lord.
were that they were all great devotees of the Lord.
Please, my
And
lords.
the Lord appeared or pleased because of the devotion.
Please, my lords.
So
Devotion.
that is a quality of a believer.
My lords, there is belief, but the Lord does not turn away any believer or anybody who has even half a belief, as long as you respectfully come. Then it is not man's province to push away anybody who comes respectfully in belief, or without belief also. Belief can come later. Even
They understood that. Also.
please, my lord. So I don't want to pitch it too high, and I'm if I can come back to page 6 of my written submission, paragraph 17. A collective is composed of individuals. The collective enjoys derivatively the rights its members enjoy. To this, it adds by Article 36. I'm sorry, my lord. The right to manage. Management is not a freestanding fundamental right of belief. It is an instrumental right. The right to manage is not a right to mismanage. As held in Nelson, even otherwise, rights under 25 and 26 of the Constitution are not absolute and unfettered. The right to manage, it goes without saying, does not carry with it a right to mismanage. The proposition that Article 26 produces some new species of right larger than the rights of the members would be a startling one. It would mean that a community could possess, qua community, a right to do things which no individual within it could. The Constitution gives no warrant for so strange a proposition. It is submitted that the right of management is only the right to regulate individuals in a matter consistent with public order, health, and morality. Any reading that produces the result that a community's right to discriminate is greater than the state's power to forbid discrimination is an absurdity. Then, my lords, the doctrine of harmonious construction, my lords, that I've already addressed with regard to the hierarchy of rights versus individual rights versus collective rights, my lords. Again, it is my respectful submission, and I adopt what Mr. Gupta and what Mr. Raju Ramchandran have earlier said, that it is the individual who's at the heart of the matter. The dignity of the individual, which has been guaranteed in our preamble, that has to be protected, my lords. Then, our untouchability abolished in any form. The text is set out, my lords, and if your lordship turns to paragraph 27. On 29th November 1948, Article 17 came up in the Constituent Assembly, and Mr. Naziruddin Ahmad moved an amendment to read, "No one shall on account of his religion or caste be treated or regarded as an untouchable, and its observance in any form may be made punishable by law." Mr. Naziruddin Ahmad and Professor K.T. Shah pressed the Assembly to confine the provision to caste and religion. Dr. Ambedkar declined to accept that amendment. The Assembly negatived it. Article 17 was adopted in its present unqualified form. The Assembly therefore considered and rejected the very narrowing that the petitioners now press upon this court. My lords, I've put that also, the relevant ones, my lord, the verses your lordships may skip over. Then the analysis for potentiality of at page 10. Analysis of potential conflicts between Articles 25 and 26. There is a potential for a clash between Articles 25 and 26.
This argument is also.
That has been over, my lords. And if I may turn to paragraph 36, constitutional protection for religious belief from a rationalist perspective. The rationalist protects religion fully within its constitutional sphere. He does not seek to abolish religion. He does not ask this court to declare any religion false. He does not ask this court to declare any belief untrue. The rationalist asks the court to enforce 4 limits, all of which are written in the Constitution. The limits of public order, morality, and health, the limit of the other provisions of this part, the limit imposed by Article 17, untouchability, the limits imposed by 14 and 15, equality and non-discrimination. These limits are not rationalist limits imposed on religion from outside. These are constitutional limits accepted by the Constituent Assembly. The rationalist within these limits leaves religion untouched. Well, then, as far as conscience is concerned, and then the heart of the submission with regard to what the society concerned, MANS, the Maharashtra Andhra Committee does, at page 13, distinguishing religious practice from unprotected superstition. The task of distinguishing religious practice from unprotected superstition necessitates a nuanced approach. The petitioners rely on a familiar critique of the arbiter of Gajendra Gadkar. This is Mr. Sirwai's critique, which Justice Inu Malhotra relied heavily on. The critique runs that when the learned judge said that protection under Article 26 extends only to practices that are essential and integral to a religion, and that mere superstitious accretions or purely secular activities clothed in religious forms may be carefully scrutinized, he in effect substituted the view of the court for the view of the denomination on a matter intrinsic to religion. The further charge is that one man's superstition is another man's faith, and that judges are not theologians. With respect, this critique is unsound. Gajendra Gadkar did not contradict Mukherjee in the Shirur Mutt case. He clarified him. Mukherjee had said that what is essential to a religion must be ascertained with reference to the doctrines of that religion itself, which presupposes that essentiality can be tested. Gajendra Gadkar carried that proposition to its natural conclusion, where the claim is to a practice that is plainly extraneous to the doctrines, or is a recent accretion, or that is in substance a secular activity wearing a religious dress, the court is not bound to accept the denomination's self-certification. This Justice Gajendra Gadkar's passage in the Ajmer Dargah is a clarification, not a contradiction. In any event, the present case does not require this court to enter the territory of essentiality. The interveners do not ask the court to label Sabrimala superstition and strike it down on that aspect. They ask the court to apply the Constitution. The Constitution does not require the court to label any belief. It requires the court to apply Articles 14, 15, 17, 25, and 26. It is further submitted that at least 3 legislations have made a sound distinction between practices that will be protected and practices that will not be protected, even if based on some beliefs that may arise from the practice of religion. Here, my lords, I'd like to draw your attention to the actual document, my lords. The Karnataka Act is at page 53 and it is relevant at 58. If your lordship kindly allows me to place that. नहीं है मेरे पास तो. Your lordships, may I just place the objects and reasons? An act to protect the common people in society against evil and sinister practices and to combat and eradicate other inhuman, evil, sinister practices propagated and performed in the name of the so-called supernatural or magical power or evil spirit, commonly known as black magic by conmen with sinister motive of exploiting, etc., my lords. A government has actually made this. Now, if your lordship turns to 57 at section 15. For the removal of doubt, it is hereby declared that nothing in this act shall apply in respect to the following, namely, the form of worship known as pradakshina, yatra, parikrama performed at religious spiritual places, harikatha, kirtana, pravachana, bhajana.
Where are you reading?
Page 57.
Yes.
Savings. Bhajana, teaching of ancient and traditional learnings, to state about the miracles of deceased saints, propagation, publicity, circulation of the same, propagation, distribution of literature about miracles, etc., my lords. These are all passages which the legislature consciously makes a decision. This is part of religion. We will not go there. Now see what they go into. See the schedule. And in the schedule, there are various practices which are set out. But if your lordship can permit me to place 10 at page 58. Practicing of evil practices against women by forcing isolation, prohibiting re-entry into the village, of facilitating segregation of menstruating or postpartum women and subjecting women to inhuman and humiliating practices such as parading them naked in the name of worship or otherwise such as Betale Seve. Then, my lords, 12, facilitating any person or persons to roll over Urlu Seve on the leaves of leftover food by other persons in any public and or religious places or similar practices that violate human dignity. My lords, there are certain temples where after people finish the ritual meal, there are some devotees who roll on those leaves. A form of abasement or surrender to anything that is there in religion. That a state government has prohibited, my lords. And these are the kind of things where there are lines. It's not as if lines cannot be drawn. Lines have been drawn, and any line drawn by the state should not be totally exclusionary in nature. There has to be a reason. I just want to show that this is not only one government that did it. The government of Gujarat.
See, there is no force. Nobody is forced to do Urul Seve or what you call that. There is a particular Seve.
Betale Seve is Madesnana.
Madesnana. Nobody is forcing anybody. A person who wants to consciously do it is attempting to do it.
In a religious public place. In a religious public place.
That is the right.
The law can, it is my respectful submission, that in a religious public place as a matter of social reform, the law can get in. Because what happens in a religious public place then transmutes to society. My lords, it's like this. It is like
forcing every person who visits the temple to perform Madesnana, definitely the state can step in because it is a matter
Let me
of
get-
their conscience.
Please, my lords.
Here,
Let me gi-
those who want to do it, they are doing it. But if you.
Even if you want to do
says
it,
that anybody
do not
can
do it
stop
in a public place.
Then it is bad.
Even if you want to do it, you will not do it in a public temple. That the state can certainly say, my lords. That's my submission. Let me give your lordship another example. Today there is a temple in Uttarakhand which says that unless you have Panchagavya, you will not enter the temple. That's a sampradaya, a new sampradaya. It will turn away many of us who may want to visit it. We may visit the Tadakaveri, but we will not visit the Gangotri. If a practice wearing religious clothes is so irrational,
Mr. Agade, the only issue is that
please, my lords.
we are right now not examining the
Today you're not
constitutionality
examining,
of-
but I.
constitutionality
Sorry, my lords,
of
yes.
a piece of legislation reflecting the will and wish of the people through their elected representative. We are, as of now, there is no such provision before us.
In fact, I'm very grateful to your lordship for that question, and that is precisely why.
The state steps in under 25(2).
Please,
That's
ma'am.
a different issue that can be subject matter of examination. And it's a case of social reform or
Please, ma'am.
feeding into 25. That can be always examined.
I am very grateful for that intervention, and my lords, that gives me an opportunity to request your lordship once again that please do not see this only through the lens of Sabrimala. Please make it about in re 2526. My lords,
We are requesting all of you that please ignore, don't be under the heavy burden of Sabrimala.
and if your
Beyond
lordship
that.
changes the title, it would also help later for legal researchers, legal this one. You don't say Kantavara so and so 1, 2, 3. In re 2526, my lords, is the argument, and there, my lords, I could end on a note of a magistrate, the great Akbar Ilhabadi, who once said, "Mazhabi बहस मैंने की ही नहीं, फालतू अकल मुझ में थी ही नहीं." I'm grateful.
Thank you, Mr.
My lords, should we start after lunch, my lords? Should we start now?
Pardon?
Yes. I'm so grateful, my lords. My lords, I'm also going to be handing over very short supplementary submissions because I only want to address your lordships and trouble this very exciting 9-judge bench, my lords. It is my first 9-judge bench argument, my lords. I wanted to only assist this court as an officer of this court in the context of legal interpretation of some constitutional provisions and nothing more. I am here only in an IA, my lords, an IA that was filed by Swami Agnivesh. You will recall, my lords, the founder of Bandhua Mukti Morcha, who gave us public interest litigation. He has since passed away after the filing. But, my lords, I am only here to assist your lordships on the law. And only that, I will make 3 substantive legal submissions which have not been made so far to assist this 9-judge bench. Now, I will say this, my lords, and I must start with this, as it is a pre-lunch starting, my lords. I will start with this, that Ms. Jaising, who has led us and opened for us very eloquently, and Mr. Gupta had looked at this portrait of Mr. Mukherjee here. And my lords, when I started practicing law, I was a junior at the then Attorney General's office, Mr. Ashok Desai, who was my senior. And I started practicing law when I was 22 years old. When I first came into these courtrooms, I used to come to court at about 9:30, 9:45. The Attorney General's office was upstairs, my lords. We would have conferences. And I went from courtroom to courtroom in the morning. I was so excited to be before the Supreme Court. And I looked at the walls and I saw not one woman. It is an important matter that your lordships are seized of today in the question of constitutional law. because exclusion comes in many forms, in many ways, including at the highest temple of justice. So it is my hope, you know, my lords, it's a strange thing.
Yeah, now the trend is, what you could foresee, after 20 years, you will be there, we will not be here in practicing. Then you will be looking for a man here.
My lords.
Go by the trend.
You will have a 9-judge bench completely of women.
Yes. You know, my lady knows that Justice Ginsburg in America was asked.
Only supplementing with one statement.
Yes.
We don't want to see them in portraits. We want them see alive.
Yes. And so it is two things, my lords. I remember Justice Ruth Bader Ginsburg of the American Supreme Court was asked, how many women is enough? It was a 9-judge bench there on, and she said, when all 9 are women. But I will say this.
An extreme statement because we cannot
think it was
do
said
away with men.
I think it was said
They
in
should
jest,
have a
but
balance too.
it is this. I'd like to make this point that it is my hope
Perspective is also
that
an
when
important.
Justice Nagaratna becomes chief, we will have that first portrait. And might I also add that I think it is only befitting if Ms. Jaisingh's portrait were put up as well, because she has defended the Constitution.
Made it very clear, I love my freedom. I don't want all this, my lord. Never mind.
My lords, now may I start, my lords? But my lords, the gentlemen behind the throne are here, my lords. I'll start after lunch, my lords. I'm grateful.
Yes, we'll continue up.
Yes, grateful, my lords.
I didn't mean.
Sorry. sorry.
May it please, my lords. Lordships will see, my lords, I've handed over some additional written submissions. This is in volume 2.7, but I've also physically handed this over to your lordships. They're not all submissions. Some of them are annexures to those submissions. Now, there are 4 propositions that I'd like to advance, my lords, my lady, which I believe are distinct from what you've heard before. The first proposition, and I'll be very quick, and the submissions are here. The first proposition is this: the Constitution envisages the reform of Hinduism, and Hinduism has confidently accommodated such reform. And I'll make good on this submission. And that is the confidence of the religion, that it has engaged and accommodated such reform. 2, and this is important, the use of the word manage, my lords will see in Article 26, as opposed to control. And this has not been advanced before. The use of the word manage in Article 26 and not control reflects the constitutional intent to harmonize denominational rights with individual freedoms under Article 25. And I'll make good on this proposition by showing you with references from the Constitution where control is used and where manage or management is used, and how that has been anticipated to mean very different zones of power. My lords, 3, the test of proportionality, and this speaks to Justice Bagchi's point made yesterday. The test of proportionality ought to be employed to resolve conflicts between individual rights and group rights, as well as competing claims inter se. And I'll take your lordships through this test of proportionality. Morality under Articles 25 and 26 is an extension of the core values of the Constitution. Whatever we may call it, my lords, constitutional morality, constitutional ethos, whatever be it. But this is really an extension of the core values of the Constitution. And finally, the word sections of Hindus in Article 25 2b of the Constitution includes women of all age groups within Hindus. Now, my lords, may I just take you to page 3 of my submissions? This is internal page 3. It's likely to be PDF 7. Why do I say that the Constitution envisages the reform of Hinduism and that Hinduism has very confidently and with ease accommodated such reform? First, textually, my lords, your lordships may please see. Now, the Indian Constitution's framework occupies a unique position in constitutional law. Unlike Western democracies and Western constitutional trajectories, say the US or Germany, which are unfettered rights of religion. So the US Congress shall make no law respecting an establishment of religion or prohibiting the free exercise therefore. So Congress is not expected to interfere. Germany, freedom of faith, conscience, freedom to profess a religious or philosophical creed shall be inviolable. The undisturbed practice of religion shall be guaranteed. This is the Western ethos, my lords. The state does not interfere, to put it very bluntly. That is not our constitutional ethos. That is not our constitutional ethos. Our constitutional ethos is a little distinct. It has confidence in the faith we profess, while also exhibiting confidence in the Constitution we hold dear. That is the Indian way. And that is why we are here before your lordships. And why do I say this? I say this because this is not just about Articles 25 and 26. Please see, this starts much earlier. This starts earlier in the text of the Constitution, and it starts while the Constitution is being framed.
It's just like this in the French idea of la cité.
Yes, my lord.
State is non-religious.
My lord.
In India, the state is religious agnostic.
And the state, my lords, not only is religious agnostic, it does more. It reforms. We are, in that sense, a classical Indian welfare state. It is unique to us. It is unique to us. That is why Indian constitutionalism is unique. Not because at a comparative level we have freedom of speech and expression. Not for that, my lords. For this, it wades into ways of life.
It has an intent to reform the religion. Reform is with respect to the society.
Yes. Yes,
That's the difference.
yes, yes,
Except the third part of 2025
yes.
The way
And
it confines only to the Hindu religion.
but my lords, I'm saying, my lords, we can see from before 2526. Please see, my lords, bottom of my page 3. Your lordships will see the constitutional, my lords all have this. This is paragraph 1.4. The constitutional framework for reform within Hinduism is reflected, my lords, in the following provisions of the constitution, which seeks to eradicate practices like caste discrimination, untouchability. Now, please even see articles 15, 2, 3, and 4. We're coming to 25 and 26, but please see articles 15, 2, 3, and 4. Prohibition of discrimination on grounds of religion, race, caste, sex, place of birth. No citizen shall, on grounds only of religion, race, caste, sex, and place of birth, or any of them, be subject to any disability, liability, restriction, or condition. Please see 2B. The use of wells, tanks, bathing ghats, roads, places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. This is, in fact, illustrations of caste used to be practiced. Hence this provision. Please see the next set of provisions. Nothing in this article shall prevent the state from making any special provision for women and children. 15.4, or making special provision for the advancement of any socially and educationally backward class of citizens or for scheduled castes and scheduled tribes. So the constitution wading far in, my lords, to address what is accumulated thousands of years of discriminatory practice.
Under Article 25(2), it's not restricted only to Hindus.
Absolutely. I'm coming
Social
to that, my lords.
welfare and reform is in respect of all religions.
Yes, my lords, and I'm coming to this.
As far as Hindus are concerned, opening of all religious institutions,
Yes, of a public character.
public,
Of a public character.
every section
Yes,
and class.
absolutely. And I'm coming to each of these, my lords. And I'm only pointing to this.
Because your note says only reform of Hinduism.
No, my lords, because my mandate here speaks to one particular issue of temple entry. But I'm also pointing to 15.2b, the use of wells, tanks, bathing ghats, because this language is familiar to your lordships, because the statute in question
Hinduism-
also refers to this.
You can say religion or caste.
So, my lords?
Instead of 1A, say reform of Hinduism through constitutional provision.
Yes.
You can say that
Social reform.
the reform of the social reform which will have an impact on religion or caste.
Religion or caste. And the practice of caste, my lords, we must be honest, has been also specific part of Hinduism. We must be confident of this old religion, our faith, to also say that it has some practices that needed to be reformed out, that still need to be reformed out. And that is the confidence with which we must wear our faith, my lords. This is my point. Now, my lords, may please see, so Article 16.4, my lords, public employment, again speaks to backward class of citizens. 17, the abolishment of untouchability. Untouchability is abolished and its practice in any form is forbidden.
But-
Now we come to 25.2b.
16.4, you have to read with 16.5.
Yes, my lords.
It carves out some posts of religious nature from,
Yes, I bow down to that, my lord.
from the equality paradigm.
Yes, in fact, I'll read 16.5 out and I bow down to that. My lord is absolutely right. May I just read, my lords, 16.5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. I bow down to this, my lords.
Even hereditary.
Even hereditary. And therefore, you have a long list of
Because
cases.
Sheshmal's judgment does not refer to 16.
Yes. Yes, my lords. Yes.
Until and unless you hold Archaka post is a secular post.
Yes. So, my lords, this is, in fact,
Is an exception.
I would say, the revolutionary nature of the Constitution, which does not believe itself to be an instrument located in a land which does not deeply and have an intimate relationship with religion and faith. It understands that it is an instrument of change in a land of faith, of belief, where religion will be a guiding factor, but also has the confidence to say that we must reform. That is the confidence that it has. And while the constitution is being written, this is not happening in isolation, the textual provisions. The point that I will demonstrate to my lords is that the temple reform statutes, the entry provisions, are also all being passed in the late 1940s as the constitution is being written. You are having this happen simultaneously. So in the morning, where the constituent body sat as parliament, and in the afternoon, that same constituent body sat as a constituent assembly. And might I also say, my lords, they not only...
They are state enactments.
They're state enactments, but I'm coming to then what happens in the context of the Hindu code reforms. I'm coming to this, my lords. This is all in the submissions. I'm coming to this. These are central, that is central legislation. And might I say, the fortitude of the framers, that not only are they a dual function body, parliament by morning, constituent assembly by afternoon, but they are also located in a city where partition era refugees are flowing in. And they can see that as they're sitting in that princely chamber. So the burden of how do you imagine a new nation to be was never intended to be a new nation without faith. It was intended to be a faith which was open and inclusive to all. There are two ways of enhancing your faith in terms of numbers. One way is through propagation. The other way is through emancipation. That is also how you increase your numbers. And I think the Constitution was wise to this. Now, my lords, may I just come back, my lords, to page 4 of my submissions. And I'm at the base of page 4. Because I do not believe that any constitution hearing can not start with a reference, must start with a reference to Dr. Ambedkar. Usually, when I argue constitution cases, I cite him in the Constituent Assembly. But today, I want to cite him for the man that he was. Because prior to the Constituent Assembly, there was also a man who had a lifetime of experience of experiencing caste. Now, may I go down to the bottom of page 4? My lords, has this paragraph 1.6. Even Dr. B.R. Ambedkar, speaking of temple entry, was not allowed entry into the Puri temple in July 1945. This was a little under a year before the constitution was complete, owing to his caste. And he was there with Lord Mountbatten. But Lord Mountbatten, who was accompanied by Dr. B.R. Ambedkar, was accorded a red carpet reception by the Jagannath temple. In his biography, the incident is captured in the following words, the parts in bold. He talks about how during his recent visit, he could have only a distant view, page 5, top of the page, of the famous Jagannath temple at Puri from the terrace of a neighboring house, unquote. This is, my lords, in 1945, the practice and the treatment.
We are aware of this incident.
Yes, yes, my lords. Now, my lords, therefore, now to my lady Justice Nagaratna's point, para 1.10, between 46 and 50, while the Constituent Assembly was engaged in framing the Constitution, independent India was simultaneously undertaking a comprehensive codification and reform of Hindu personal laws. This is page 5, paragraphs 1.11. Dr. B.R. Ambedkar, during the debates of the Hindu Code Bill, underscored the necessity of reforming Hindu laws despite the views of the majority by observing that, quote, "Sir, much has been made of the fact that there is a great deal of public opinion which is opposed to this bill." And these are the Hindu Code bills. I have certainly not weighed the opinions that we have received, but I do like to say this, that this is hardly a question which we can decide by counting heads. This is not a question which we can decide in accordance with the opinion of the majority. When society is in a transitory stage, leaving the past, going to the future, there are bound to be opposing considerations, one pulling towards the past and one pulling towards the future. And the test that we can apply is no other than the test of one's conscience. I have not the slightest doubt in my mind that the provisions of this bill are in perfect consonance with the conscience of the community. And I have therefore no hesitation in putting forth this measure although it may be as a matter of fact that a large majority of our countrymen do not accept it. So, my lords, the pressure of saying, but does a popular majority, will they abide by this social reform? The pressure of saying that, will this be an unpopular act of reform? So when the Hindu Marriage Act, the Hindu Succession Act, the Hindu Adoption and Maintenance Act, all passed, now page over, my lords, page 6, all passed, starting reform processes start in the late 1940, passages of these statutes is in the early 1950s. Please see the act of parliamentary courage, of parliamentary conscience, that shortly after the first elections are held, this is the reform that is envisaged by our parliament at that time. This difficult reform, ascribing marriage rights, ascribing divorce rights, allowing for intercaste marriage, all of this was made possible by the codification of these statutes.
None of these reached Article 25(1).
I'm coming to this one. I'm coming to this. I'm coming to this, but they are envisaged. They are envisaged by Article 25. That is the point. That this reform is not just this central legislation, that this reform starts from Articles 15 onwards.
Today we are debating whether there is a violation of Article 25(1).
Yes.
In certain practices being followed or not.
Yes, I'm coming to 25(1) immediately. Now, my lady, please see paragraph 1.15, 25(1). Instantly to my lady's point. My lady has that?
Yes, yes.
Article 25 reads as follows. Freedom of conscience. This is the conscience that Dr. Ambedkar was referring to earlier when he's talking about reform of the Hindu code. Your conscience must accept and envisage reform even if the popular majority does not. Your conscience. Freedom of conscience, free profession, practice and propagation of religion. So this is a truncated right of religion. It is not a free, unfettered right. Unlike Germany, unlike the United States, this is a truncated right. Why do I say it's a truncated right? Because it is in fact subject to public order, morality and health and other provisions of Part 3. And I'm not going to belabor this because this has been argued at length. This has been argued at length before my lords, but this is the nature of the right that is before you today. That this is not an unfettered, unrestricted right. It is a truncated right that is passed on the back of legislative reform that is happening simultaneously and deep introspection within the constituent body as to what in our faith must be reformed. That is why conscience is there. The language of 25, my lords, if your lordships will see para 1.16, the language of 25 makes it abundantly clear that the drafters gave preeminence to the right to freedom of conscience and hence placed it before the right to freely profess, practice and propagate religion. The reason why such emphasis is given to the right of freedom of conscience is deducible from the Constituent Assembly debates Mr. K. Santanam while drafting Article 19. My lords, may I just read the extract? It is also in the compilation. This is what Mr. Santanam says. Hitherto it was thought in this country that anything in the name of religion must have the right to unrestricted practice and propagation. That is exactly what 25 is not. It is a truncated right. But we are now in the new constitution, restricting the right only to that right which is consistent with public order, morality, and health. The full implications of this qualification are not easy to discover. Naturally, they will grow with the growing social and moral conscience of the people. For instance, I do not know if for a considerable period of time, the people of India will think that so-and-so is consistent with the health of the people. Similarly, there are many institutions of Hindu religion which the future conscience of the Hindu community will consider as inconsistent with morality. So there are deep conversations, deep, intimate conversations, which are introspection of the balance between reform, rights, and faith. And the constitution makers are alive to it. The parliamentarians in the early 1950s were alive to it. And I'm sure my lords will be alive to it today in 2026. a good 75 years later. So it is evident that the right to freedom of conscience is an embodiment of the spirit of reformation, which the makers of the Constitution found as an inalienable principle of a civilized society. Now, my lords, I'll skip the rest. 1C, my lord, the Chief Justice knows that this point on truncated rights has been made. I'm not going to read it again. I'm only going to take you to paragraph 1.23 at the bottom of that page. Just at the bottom of that page. And this is the debate and the discussion when Article 25 of the Constitution was presented in the Constituent Assembly as draft Article 19. So the Constituent Assembly had these same dilemmas, which my lords are today seized of and likely confronting. And this is what Pandit Lakshmi Kanta Maitra had to say. And perhaps my lords will find some comfort in this. This Article 19 of the draft Constitution, this is the bottom of the page, confers on all persons the right to profess, practice, and propagate any religion they like. But this right has been circumscribed by certain conditions which the state would be free to impose in the interests of public morality, public order, and public health. And also insofar as the right conferred here does not conflict in any way with the other provisions elaborated under this part of the Constitution. And similarly, my lords, page over, Mr. Santanam, while supporting draft Article 19, which is Article 25 in the form that is before my lords, says this: therefore, I submit to you that this article as it is not so much an article ensuring freedom, but toleration for all, irrespective of religious practice or profession. And this toleration is subject to public order, morality, and health. Therefore, this article has been very carefully drafted, and the exceptions and qualifications are as important as the right it confers. Therefore, I think the article as it stands is intended to our wholehearted support. And similarly, draft Article 35, which is now Article 44 was being discussed. Mr. Munshi, when speaking about a uniform civil code, said this, that you can never give, for instance, equality to a woman if you hold that personal law of inheritance succession is really a part of their religion and therefore not amenable to social reform. This speaks to specifically the point that my Lady Justice Nagaratna was making on the central legislation. If that was so, you can never give, for instance, equality to women. You have already passed a fundamental right to that effect. You have an article here which lays down that there should be no discrimination against sex. Look at Hindu law, you get any amount of discrimination against women. If that is part of Hindu religion or Hindu religious practice, you cannot pass a single law which would elevate the position of Hindu women to that of men. So our drafters were alive to the same dilemmas that your lordships are faced with 75 years later. The difference is simply this, that your lordships have the benefit of the introspection of the drafters, the fruits of their introspection, which is the text of the Constitution, which reads in a certain way, and the knowledge that Parliament, even at the time of founding of the Republic, in those very difficult times, had the courage to wade into Hindu law and pass reform, social reform, as Mr. Munshi will say, in the context of marriage, divorce, inheritance, succession, guardianship, maintenance. So to that extent, if I may be cheeky to say this, my lords, your lordships have a lesser task, my lords, than the framers did at that time, minus partition happening outside this building. Now, my lords, I'll take you to the second proposition. The use of the word manage in Article 26, I believe, reflects the constitutional intent to harmonize denominational rights with individual freedoms under Article 25. May I straight away take my lords to Article 26. And this is a textual argument because black letter law matters, the text of the Constitution matters, and sometimes the text is simple enough to make clear what otherwise interpretation may not. May I take you to Article 26, freedom to manage religious affairs. My lords have this. Subject to public order, morality, and health, every religious denomination or any section thereof shall have the right, A, to manage and maintain institutions for religion, religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire property, to administer such property in accordance with law. So C and D, I leave out. Let us please focus, my lords, my lady, to manage its own affairs in matters of religion. Now, my lords, the word manage is not a matter of chance. It is a matter of explicit intention, because the word used is manage, not control. If the word in 26B had said to control its own affairs in matters of religion, then we would be in a zone of power and the exercise of power which is beyond this court. But the framers use the word to manage its own affairs in matters of religion. Now, why is this important? May I take you to page 9 of my submissions? Paragraph 2.4, bottom of the page.
Yes, the word manage.
Yes. Articles 25 and 26 of the Constitution must be harmoniously interpreted so that the right to manage found within 26 does not eclipse the rights under 25. The makers of the Constitution, while constructing Article 26B, deliberately use the word manage instead of the word control, which denotes legislative intention. The word manage, this is paragraph 2.5, bottom of the page. The word manage has been defined in Black's Law Dictionary as to, quote, to exercise executive, administrative, and supervisory powers, whereas the word control has been defined to regulate or govern. It is evident that the right to control is in a broader spectrum, whereas the right to manage is limited and denotes administrative functions. 26B of the Constitution does not bestow upon religious denominations any right of control, but rather a much more truncated right of managing. The use of the word manage in place of control is intentional, as the Constitution, while dealing with other provisions, has explicitly used the word control. Now, where has the Constitution done this? May I take you to Article 243 ZH of Part 9B of the Constitution, for one instance, which speaks to cooperative societies. May I just read that article out, my lords? It's Article 243 ZH. I've reproduced it here, definition, and this pertains to cooperative societies. 243 ZH, in this part, unless the context otherwise requires.
What purpose you are reading this?
No, I'm reading this to say that they intentionally used manage and not control, because where they intended to give that zone of power, they use control. Like, for instance, in the context corporate.
That's home. Okay.
No. Yes, my lord. Please.
There are two things.
My lord.
See, it only says manage the religious affairs.
Yes.
Affairs of the religion.
Yes.
Affairs of the religion is definitely different than the religious belief and practice on the one hand is totally different.
Yes.
But see, a group of people, they have a belief and then followed by a practice.
Yes.
That practice is being managed by them by an affair.
Yes.
So therefore, there is no need to read into 25(1) so far as this is concerned. What has been available in 25(1) is being managed and forwarded by the common belief to this denomination. It manages it. It manages the affairs. How to give effect to. Like when 25(1) says practice, profess.
That's right.
Propagate.
That's right.
That's what is being done.
But it is.
This distinction is, if you say as against the instrumentality of the state or something like that, then probably the issue might come.
No,
But
my lords.
You can't use this as against individuals.
No, my lords, it's not about using it against individuals.
Yes.
It is about the zone of regulatory power that is envisaged under the text of the Constitution. Only in that context. So if it said control, That is a higher zone that is envisaged. You can be a new denomination. You can actually recognize.
Doesn't make any difference, whatever you use.
No, my lords, I think it does make.
You can say, how long the power is there available for the state to regulate it, that doesn't make any difference.
Article 26
Yes.
is to protect. It is a protection.
Yes.
For example, we'll say, if there is a hut where Mahant or Tamat can choose his disciple to be the successor.
Yes.
In such cases, the state cannot interfere. That is the object. To protect whatever is, it is a religious, to manage its own affairs in matters of religion means, suppose there is a mutt belonging to a particular denomination. The particular head or the Mahant, the Guru, whatever you may say, wants a disciple. His right to select a disciple, that cannot be interfered by the state. That is a protection which is given under 26
We can,
to a denomination.
No, my lady, may I just? Yes.
You can't go and make inroads into all this.
Yes.
we put your argument this way.
Protection.
Yes.
The word manage will have to be given a restrictive meaning.
That's right.
To the effect that religious denomination cannot take the role of the believers and do it on its own. Because it can only manage what is conferred to you by under 25(1).
Yes, and neither can it create new practices.
That to that extent you are right.
Yes, and neither can it create new
You
practices.
can't have something more than what has been conferred.
That's right, and you cannot create new practices. So it is to that extent.
You are more like a power of attorney holder.
Yes.
And delegate.
That's right.
That we get.
That's right.
All right.
That's the point, my lords. That is the point. So, my lords, may I just take you to paragraph 2.10. Manage under Article 30 of the Constitution, which also uses the word manage. There is a reason why management is the right ascribed as opposed to control. Please see this. Even the right of minorities to manage their institutions. My lords have this, paragraph 2.10, page 10. Even the right of minorities to manage their institutions under Article 30 are circumscribed as held by a 6-judge bench of the Supreme Court in state of Kerala versus Reverend Mother Provincial 1970. Administration means management of the affairs of the institution. That is the import of this word.
Protection.
Yeah.
Because they are minorities, they have certain unique, characteristics. To protect the minorities in respect of their affairs. That article,
No, but
Article 30 is there.
May I just read this extract out, because I think it makes the point and answers my lady's question. May I just read this extract?
What was India in the 1950s or late 40s? What was inherited? What were the drawbacks in the society? That is on one aspect on which the Assembly has debated and given its various provisions under the articles. But the framers were most conscious of what should be protected, that the civilization must continue. And therefore, they have come to certain, articles are framed in particular way. Today, are we as a 9-judge bench going to upset the civilization is the question.
I would reframe what my lady says and say this, that the framers were confident that by reforming faith and reforming religion, they were not upsetting a civilizational balance. I think that is the confidence of the framers.
Draw a line. There has to be a line drawn.
I think that is the confidence of the framers. But I believe the framers were...
What is happening? The line now, it is given to, we are given to understand that the line must be blurred. That cannot be.
But my lady, with great respect, I would disagree on this point that reform in any way upsets civilizational balance. Sometimes civilizations are enhanced when there is social reform. And I think that is the point. That is the point.
We are not saying there should be no reform. There has to be a balance.
On the issue of expression management or manage word.
Yes, my lord.
I think there is no dispute.
Yes,
that
very well.
The word, the expression manage is, it rather reflects a
lesser degree. Yes.
on me, but it is subject to certain conditions.
Yes, my lord.
Those conditions are, as my brother has pointed out, 25, one is there, 25 and then 20.
And part 3 also, my lords. And part 3 also. Part 3, public order, morality, but it is used intentionally. May I just finish reading this one extract which speaks to management, and then I'll move on.
The dictionary expression which you Black's dictionary, that includes, because this definition is inclusive.
Yes.
So executive, administrative and supervisory powers, all are components of management. Probably management expression has a greater autonomy in terms of that. And that's why in Article 30, you rightly pointing out the word establishment, then to run the affairs and to manage the affairs. All three components are there.
Yes, so may I just read this part out, my lords, on management of the affairs of the institution. There's just an extract. This is a 6-judge bench. For instance, because it makes the point on what is the distinction. So this is 2.10. Standards of education are not a part of management as such. The standards concern the body politic and are dictated by consideration of the advancement of the country and its people. This is on what management of the affairs mean.
This management, I think, probably, we should be very clear. This management pertains to religious affairs, not religious practices. That we
Yes, and that is all it pertains to. It is not just,
understandable.
yes,
Understandable.
it is administration of that institution or that denomination, and within that, a lesser degree, because there is a higher degree of control if it were not management. That's all. That's the point. That is the point.
No, Dr. Guruswamy, probably you are trying to juxtapose control with management. They are totally in separate paradigms they operate. Control is with regard to institutions which are created. If an institution like a cooperative society is created, it has a managing committee. Now, who would control that managing committee? So the control is with regard to that committee, not to the organization. Here it is different. You establish an organization and you manage it. So this control is with regard to a body created of an institution. Who will be in control of that? So, they are two
So,
different
but my lord, when
probably
you
does not be clear.
control an institution, when you control a body corporate, or when you control a cooperative society, there are many things you do in addition, which you do not do when you only manage. And those things include coming together in terms of the articles of association, putting in place rules, putting in place a certain framework. Here, the degree of autonomy is a lesser degree. That's the only point I'm trying to make. That is the point, that it is a lesser degree of autonomy. Yes, yes. Now, my lords, page 11, the right of entry into a public temple is a subject of 25 and cannot be made subject to 26b. Now, my lords, may I just make this point, that the state has been vested with the exclusive power under Article 25(2)b to throw open Hindu religious institutions of a public character and enable entry of individuals into public temples. When a right has already been specifically granted to the state under 25, there is no conflict created merely by using the word manage in 26. For instance, in the Shabrimala case, women were historically permitted. This is in the judgment, the 5-judge bench decision. Accordingly, where a purported denomination invokes its right of management under 26 to displace an existing custom permitting women's entry into a public temple, this would be ultra vires the Constitution and Dehaul's Articles 25 and 26. Now, my third point, my lords, is that judicial precedents have to be harmonized. So they have to harmonize Articles 25 and 26 in possible situations of constitutional conflict.
No, you are right.
This pertains to Devaru.
Right.
Yes, and this pertains to Devaru. I think your lordships have been taken through Devaru multiple times. I'll only request my lords to mark this here in this, and I'll only respectfully take my lords to para 2.19, which is Riju Prasad Sharma versus State of Assam. It's a very interesting case because this pertains to the appointment of priests to the Ma Kamakhya temple in Guwahati. And this is a very interesting case, my lords, because it's the sacred temple of the bleeding goddess. So it has some context to what your lordships are. And this is what the court had said in that context. There is no need, I'll just read this out, para 55. There is no need to go into all the case law in respect of Articles 25 and 26, because by now it is well settled that Article 25(2)A and Article 26(b) guaranteeing the right to every religious denomination to manage its own affairs in matters of religion are subject to and can be controlled by a law contemplated under Article 25(2)(b), as both the articles are required to be read harmoniously. This is the only argument, and your lordships have
Very precise.
very precise.
But without going into the previous precedent.
My lords, because they believe, they believe that harmonious construction resolves the dilemma. This is the only thing, that harmonious construction resolves the dilemma. And that you don't need to feel that something is a conflict or is challenging in terms of interpretation. That's all. My lords, the third proposition is this, that the test of proportionality ought to be employed to resolve conflicts between individual rights and group rights, as well as competing claims, as managing as competing claims inter se. Now, your lordships have established the test of proportionality, and this is something which Justice Bagchi had also brought up, my lords. The following test of proportionality in Modern Dental College and Research Center versus State of Madhya Pradesh. This is page 13. There are 4 prongs to this, my lord. And Mr. Gupta had actually put together 5 prongs, but I'm going to stick to the court's 4 prongs. The measure restricting a right must have a legitimate goal. 1. 2. The measure must be a suitable means for furthering the goal. Rational connection stage. 3. The measure must be least restrictive and equally effective. Necessity stage. And 4, and finally, the measure must not have a disproportionate impact on the rights holder. The balancing stage. So your lordships have confronted this in multiple cases, but the one case which I thought summed it up very briefly as well is this. Sunil Kumar Singh versus Bihar Legislative Council. It's a new decision, my lords, 2026. And the court, your lordships have said this. The test of proportionality thus applies to cases where action is brought to protect the right guaranteed by the Constitution or other laws. It largely seeks to identify whether the restriction sought to be placed on the right is proportionate to the objective sought to be achieved by the restriction. It often belies a comparison between the importance of the public purpose of the restriction on one hand and the public right on the other hand. In employing the proportionality tests, the court would need to assess the nature of the contested religious practice and the significance of its continuance against basic and inalienable rights guaranteed to the individual. Now, in the context of what is before, my lords, my first point is this, and I don't want to get into facts, but what is before, my lords, is the Kerala Hindu places of public worship rules, which respectfully, my lords, as your lordship will see, the argument is presented here, fails to satisfy the test of proportionality. That is the argument. And your lordships will see the rule itself has 6 prescriptions of who cannot enter the temple. 1, persons who are not Hindus. Women at such time during which they are not by custom and usage allowed to enter a place of public worship. Persons under pollution arising out of birth and death in their families. Drunken or disorderly persons. Persons suffering from any loathsome or contagious disease. Page over. Persons of unsound mind. This is page 14. And professional beggars. Now, my lords, respectfully, firstly, there's something a bit insulting to be compared to these various other categories, my lords. And I don't know if this should be an argument in a lighter vein or not, but to be compared to these categories of persons of unsound mind, professional beggars, etc., is also in a way stigmatizing. Let me put it mildly.
Persons who are not Hindus are also not permitted.
Yes, but Hindu women are also not permitted like these other categories. So that also creates its own stigma. But the point is this, and this is the important point because I started with this argument, that rule 3 of the Kerala rules is completely disproportionate because your lordships will remember 15.2, where we looked at what was prescribed. And what was prescribed there was bathing, discrimination in the context of bathing, ghats, wells, so on and so forth. Now, please see what Rule 3 says. It restricts women from bathing or using the water of any sacred tank well spring, or water course appurtenant to the temple, whether situated within or outside the precincts of the temple, any sacred place, including the hill or a road or a street or a pathway, which is requisite for obtaining the access to the temple. So the language of the restriction itself is the kind of restriction that was not countenanced by Article 15. And that is restrictive language that has traditionally been deployed in the context of caste. And that is why the framers had issue with this kind of language and prohibited explicitly in Article 15 itself. So when your lordships is seized of this, and I've said that in Article 15 to the next paragraph, the Constitution prohibits discrimination on ground of sex in matters relating to access to the use of wells, tanks, bathing ghats, roads, places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. So you'll see the grammatical, the linguistic similarities which speak to the recognition. This is codification of practices that were otherwise derogatory towards certain classes of people, especially in the context of caste, and it continues so in the context of gender.
So these are not the practices first time introduced in 1965. Rule 3, according to you, is rather compilation of the practices which were already prevailing.
And it is a codification, my lords. The challenge when your lordships are assessing any question of religion or faith is this. This is the actual challenge which even legislatures face. It is that if you were to leave a faith or a religion dynamic, and if it were just practiced, then through customary practice, you may see progressive reforms happening. So for instance, but when you codify something, you capture a static piece from 1963, you codify it, and we continue interpreting it 60 years later. And that is a problem with codification of any issues of faith, of religion, of personal laws. They are not intended to be codified. Where do we get codification from? We get codification because we adopted as a colonial society a certain system of law. But if you were to let tradition to be, if you were to let faith and religion to be, then you would actually see progressive, emancipative practices emerging because people go ahead. Women start occupying public spaces. People start coming to express faith. There are divergences in faith that are then expressed. The problem with codification is this. This is perhaps the situation in 1963. We are now assessing it in 2026. So what is the interpretive tool that your lordships must use? It has to be constitutional values. It has to be constitutional values. What else can it be? What else can it be? Because tradition is not stagnant. Codified law is stagnant. When you are confronted with codified law, you have to look at that else which is codified, provisions of the Constitution. And you have to look at constitutional values. So your lordships, in that context, can only look to this. My lords, finally, my lords, and I've taken a fair amount of time, but finally, on pages 16 and 17, on 16, my lords, is a short argument on morality, which your lordships have confronted. If your lordships could just mark this, my lords. But one important point which Justice Sundaresh had made, my lords, 2 days ago, which is he pointed to Article 51A of fundamental duties. And within 51A, this is page 17, includes the fundamental duty to renounce practices derogatory to the dignity of women. So there is another marker for your lordships, which is that there is a fundamental duty that expects the state and my lords to be governed by this. My lords, finally, in 25(2)(b, sections of Hindus, my lords. And I'll end with this, my lords. Mr. Gupta earlier in the day had read Durgabai proposing an amendment by which the words any class or sections of Hindus was to be substituted with all class and sections of Hindus. So, my lords, I'll take you straight away. I won't repeat that argument. I'll take you straight away to paragraph 5.4, page 18. So the point is this, my lords. The act of throwing open any public temple cannot be interpreted as an act contravening the practice of Hindu religion or the right of any denomination, as observed by Mr. K.M. Munshi in the Constituent Assembly debates, where he says this, "Sir, I move an amendment to the effect that after the last explanation, the following words may be added, and for throwing open Hindu religious institutions of a public character to any class of section of Hindus." After the explanation above was drafted, it was thought that the practice of religion referred to should not be of such a character as will interfere with the right of the legislature to legislate on social questions. The question arose with regard to throwing open of all temples to all classes of Hindus, whether it would be religious practice. In order to prevent any such construction of clause, it was decided that the throwing open of Hindu religious institutions shall not be held to contravene the practice of Hindu religion. So, for instance, the state of Kerala in the present case has enacted the aforementioned the Act, which allows all sections or class of Hindus to enter places of public worship. The same Act defines Hindus as including a person professing Buddhist, Sikh, or Jain faith. It also defines sections or classes to include any division, subdivision, caste, subcaste, or denomination whatsoever. My lords, and I'll stop with this. The rest of the arguments are in the submissions itself, my lords. And so, my lords, finally, in conclusion, a restrictive interpretation, my lords, of a section of Hindus would wipe out the rights of a state and of Hindu women, who is included in the definition of a Hindu as per the Act, to practice her religious beliefs and customs, especially when the rights of a denomination to manage its religious affairs does not include the right to deny temple entry to any section or class of Hindus. I'm very grateful, my lords. I'm very grateful.
Please, Lords. Because I appear in an intervention application, just hand over. IA number 89371. Plus, there are two professors. One is a professor of social science. One is a professor of political science. One is a scheduled caste. They're also married to each other and they've worked a lot on gender justice. Plus, in a matter like this, in a 9-judge plus, your lordships are primarily concerned with the tests rather than the outcomes. So, I will limit myself on the test on 3 points. Just hand over the written submission. My lords will just keep open my written submissions and a copy of the constitution. That's all I will refer to, nothing else. Yes, copy. Give a copy. Hard copy.
Then how much time? 15 minutes?
I will try and Mullas will give me 25 to 30 minutes. Mullas, I will be very swift. Your lordships will not have a complaint, Mullas. I can assure you that.
We know very well that
Yes.
you will never repeat and you will never.
Yes, Mullas, yes, I was aware of that. So, Mullas, the first.
The left out issues are very less.
Your lordships, I will be very swift. My lords
So you
may
can
take
wind
it
up.
from me that I'll be as swift as I possibly can. Well, the first question I'm addressing is straight away the question of constitutional morality, which is a question number 4. And your lordships will have my page 2 of my written submission. In a case like this, it's somewhat easy to present a false binary to the court. Is it constitutional morality or is it popular morality? I say it's both. It's not a question of either or. Your lordships will see how the question itself has been framed. The question framed is the word morality in Article 25 and 26 includes, whether a word morality under Article 25 and 26 is meant to include constitutional morality. Your lordships have framed it very cautiously. Is meant to include constitutional morality, not that it means constitutional morality. I say it's both. Now, how, my lords? Your lordships will, what is constitutional morality? The judgments which have expounded of constitutional morality have primarily taken it from the values of the constitution, primarily the preamble. I have, my lords, quoted the preamble at page 4. Just have it for a moment of my written submission. My lords, the preamble begins by saying, we the people of India, and then, my lords, lays down justice, liberty, equality, fraternity, and then in the end says, and give to ourselves. So the people of India have in the preamble given these values to themselves. If these are the constitutional values which the people of India have given to themselves, they cannot be not also public morality. They are part of public morality because we the people have given it to ourselves. So the constitutional values are also public morality. Well, that's point number 1. Plus, then I say that general public morality, which is popular morality, is, of course, can differ in cases to constitutional morality. in a large number of cases, because your lordships are testing morality as a restriction in 25 and 26. In a large number of cases, the public morality and the constitutional morality will lie in the same realm. For example, in cases where, my lords, there is a new religion which says that you can have sexual relations with children before the age of puberty. Constitutional morality will prevent it. Popular morality will prevent it. Both will prevent. In 80 to 90% of cases, I say they go on the same page. There is a match. But, my lords, what happens if there is not a match? And that's, my lords, there I say that in those cases, the judges will use constitutional morality to override public morality. Why? The reason is because public morality can, in a large number of instances, be just the prejudices of the society at the time and nothing more. For instance, because I have in my para 13 of my written submission given a survey of 2025 where more than 50% of Indians are against intercaste marriage. More than 60% are against interreligious marriage. That's the public morality of 2025. Your lordships will not enforce it. Single judge.
How to rely upon this kind of survey too?
Plus, your lordships, at the end of the day,
everybody knows how these are tailored, how these are prepaid.
May I say this? Your lordships will even
in the market.
My lords may, let me say, my lords may ignore this survey for a moment. Let's assume what the Chief Justice is saying. But my lords will agree with me that in a large number of cases, at a given time, the prejudices which prevail of the society change.
This may be true, but then there has to be some very authenticated data.
I am grateful. What I'm saying is this.
For me to rely upon certain things.
All right.
It can't be only because some people sitting in air-conditioned rooms writing some article with a particular prejudged agenda, and they throw certain things in the name of academia or the.
You want to rely upon this?
I am only saying this. In a given subset of public morality, my laws may ignore this example or any other example, but your lordships will agree with me that in a given subset of examples, at a given point in time, the prejudices of the society can prevail with the majority of the society. It is possible. It has happened. Because maybe there were practices, I won't even go into individual practices, which at a given point in time, most people believe, but today we see it prejudicial. So the point is this, in those cases.
It is the right of every individual to marry whom he or she wants.
Right.
Why do you say it's a prejudice?
No, I say, well, it's the society preventing them is the prejudice.
See,
Not on that now.
there are two things.
Yes.
If you will ask the survey
Yes.
to the parents and grandparents,
Yes.
the survey results will be different.
Yes.
When you will go to the young people who are in marriageable age, the survey result will be altogether different.
And that's exactly my
It all depends, therefore, it all depends upon the selective class they have chosen. That's why we are very afraid of these surveys.
So therefore, your lordships will, that's it.
Right.
Yes.
Still saying,
The responders
tell you what,
actually determine.
see, given the choice, even we have also our own differences here.
Yes.
Leave alone that you are a lawyer, we are here. There are multiple reasons maybe behind this. One is you are part of the culture. One is how far you will able to fit into the other system. There are multiple reasons. You can't say it's a prejudice. Ultimately, let us say as a parent, as a grandparent, you want to say which part there he or she will fit into.
Correct.
You can't say it's prejudice. Maybe they might feel that time has not come. There are other factors. Maybe it is good for the career progress. Maybe it is good for the life. There are multiple reasons for it. Otherwise, how do you justify now? Every sector you take it, why does it happen in a particular way? Because see, if you go into it in depth, you can't put it in the bracket of a prejudice. It's one of convenience. It's one of
Professor saying prejudice may not be the right word to use for it.
one of the economic factors, social, there are multiple factors.
All right.
Let us not go into all those things now. Yes.
I said that prevailing notions of the time may impact a certain section in a way which is not desirable by the constitution. In those cases, then your lordships will use constitutional morality
So
as
if
the
a
test.
person wants to marry
Yes.
within a particular social group or what, that can be decried. See, the diversity of India
Yes.
is one of the reasons why the people want to align. After all, it's a partnership for a life. They want to align with a similar family
A
background.
question of belief.
thank you.
You think it's a common culture, common beliefs. For example, somebody is going abroad. He might marry an Indian there or a person
May I
from
say
this
like
place. There are multiple reasons for this.
Malas, may I say it like this? I have seen,
Compatibility, there are so many factors are there.
may I say it like this? I have seen,
For the purpose of cohesion.
Yes, that's correct.
Malas, may I respond to that? Malas, I have seen, Malas, it's a misnomer that caste exists only in Hinduism. In India, caste is a social structure. It exists amongst Muslims as well. Malas, I have seen in families where, Malas, two people within a caste, within the Muslim religion, they are from different castes, but there has been so much protest and so much prevention, just like in other cases, and they have wanted to marry. Because what I'm saying is public morality at a given point. Yes.
Those are the actual examples. which
Yes,
are-
correct. Yes.
So that must be truth.
Yes.
Nobody can dispute.
Yes.
That. But we are only afraid of that while sitting here.
Yes.
Will it be safe for us to rely upon certain opinions? We do not know in what background.
Malas, your lordships may ignore. I take the question.
We are only,
Yes.
only pointing out that
Is the issue?
is it an illustration or an example
Yes.
which we can rely upon
Yes.
for the purpose of formation of a judicial opinion? We
Correct.
are only on that point.
So, Malas, that your lordships will take it when the facts come to my lords. The limited proposition is this: my lords can definitely conceptualize cases where the demands of the constitution will be different from what the demands of the society at that given point in time are. In that case of conflict, which will be, say, in 2 out of 10 cases, in 8 out of 10, they will go together. In that case of conflict, constitutional morality will prevail, and your lordships will use constitutional morality as a test and not public popular morality. That's the limited submission I intend to make. And therefore, your lordships are, in that sense, marrying morality as both constitutional morality and public morality, but in a given set of cases, one will trump the other. That's the limited submission. That's point one.
You can say we apply principles of constitution.
That's right. Malas, may
Principles
say
of
it
the
like,
constitution we apply.
Malas, your lordships can use any.
Whatever the nomenclature we use.
Yes.
According to it exists, so.
It exists. And Malas, the challenge from the other side in constitutional morality was it's a value. How do you test anything against a value? Malas, what is the basic structure doctrine? Malas, the basic structure doctrine is a value-based doctrine at the end of the day. Malas, the procedure, legal procedure was in Article 368, 2/3 present and voting, approval of the states, etc. My lord said it's not found anywhere in the constitution. There's no discussion of basic structure in the original debates of 47 to 50. But my lord said the values of the constitution mean something. And we'll test the highest power of the parliament, the amending power as sitting as an amending body against values alone. Therefore, this argument.
All of us are unanimous on this.
Yes.
That side also, that constitutional values are
Malas, paramount, especially in the area of constitutional adjudication, not like a statutory adjudication. And therefore, to say.
25 and 26 now.
Yes, on 25, 26 only. Now, my lords, will just come on the second aspect. My second submission is corrected submission on this, kindly have page 11. Because one of the questions they have raised is on morality. They use in the Hindi constitution uses the word sadachar. Malas, sadachar is not a literal translation. Naitikta is a literal translation. For morality, the literal translation in Hindi is naitikta, naitik. You do something with morals. Sadachar is good behavior. Durachar is bad behavior. Correct? So, Malas, the translation is not accurate, number one.
Right, you may be right.
Yes, well, the translation is not accurate. Mr. Gupta showed in the morning Article 394A. I just want to bring my lords to once again to that. There's a point I want to pitch on that. Kindly have 394A. 394A in my submission provides only, it has come through an amendment in 1987. That is 40 years after the Constitution. Only the English copy was authenticated by the Constituent Assembly. 394A says that the President, that is the executive, will bring the Hindi version, original Hindi version, in line with the original English version by using the terms used in Central Acts, etc. Therefore, my lords, it's an executive which is actually, in that sense, has a drafting leeway in the Hindi constitution, Hindi version of the constitution. And since that is the case, Article 394A clearly makes it a point that this is only a version for public information. It is so that public has a readily be available version of the constitution in the language which, say, at least in North India, people know. It is not meant for constitutional interpretation at all. I just want to make that point. Kindly have Article 394A, just through one portion.
Yes.
394 capital A.
Please read. Please go ahead.
Yes. Well, authoritative text in the Hindi language is the setting. The president shall cause to be published under his authority. So the president is publishing, the executive is publishing. The translation of this constitution, this kindly underline, this means the English constitution. It is a translation of the English constitution. in the Hindi language signed by the members of the Constituent Assembly with such modifications as may be necessary to bring in conformity with the language, style, and terminology adopted in the authoritative text of Central Acts in the Hindi language and incorporating therein all amendments of this Constitution made before such publication. So let's look at the role of the executive. They take the original Hindi, they have to bring it in line with the Central Acts and use the words. So executive is actually doing the job here, number one. Now kindly have B, the translation in the Hindi language of every amendment of this Constitution made in the English language. Now 2 is the most important. The translation of this Constitution of every amendment thereof published under clause 1 shall be construed to have the same meaning as the original thereof. And if the difficulty arises in so construing any part of such translation, the precedent shall cause the same to be revised suitably. So, Maharaj, if Hindi version in any way differs, you have to bring it in line with the English. And therefore, I say, Maharaj, this Hindi version is for the purpose of public knowledge, not for the purpose of constitutional interpretation, for which only the English version is relevant. Maharaj, I was just doing a...
This provision is necessitated.
Yes, Maharaj.
Because translation is always a translation.
Correct.
You translate a poem, you translate a novel, you translate a history book, you translate an essay.
Yes.
The translation will never be the same thing as the sentiments, the feeling, or the expression in the original. So therefore, the controversy may not arise. Therefore, there is a constitutional declaration that once an authenticated Hindi version is there, then it shall be treated as the translation of the original one.
Correct.
We got it.
And that's the so that's the submission on translate. Now, Manoj, the second issue, which is your lordships will have in my written submission on the nature of the test, which your lordships will employ to test what goes in Article 25. And Manoj, I'll just draw back your lordship. This obviously matter is about religious entry into religious places. So all councils have argued it in that context. But I will request your lordship to draw yourself back.
AI translation.
That leave granted, chutti svikar.
Granted, which we say, chutti svikar. Specially petition is ask chutti yachika. You see, the translator's job is more difficult to
Very,
get
very
the
difficult.
spirit of the original
Correct.
text.
So
That's-
how to find out the nearest word?
And
There is no other.
She should know both.
and a master of both the language, because then only you can understand the context. You have to master the both.
Exactly.
Otherwise, AI
Absolutely.
translations.
So, Maharaj, now I come, your lordships will have page 14.
Ask chutti yachika.
Page 13 of my written submission. Maharaj, I am now answering issue 1 and issue 4 of the reference order. Maharaj, I'm just trying to submit on that. What is the scope and ambit of right to freedom of religion under Article 25? And second, what is the scope and extent of judicial review with regard to religious practice referred in 25? Maharaj, everybody has argued in the context of entry. I will, Maharaj, request your lordships to go a step back, because there is a context of Article 25(1) rights in the context of general state regulation. These two questions also deal with that. That is, if I access a secular space, if I'm in a public space, what is my 25(1) right? Well, obviously here it arises in the 25 versus 26 context. So all relevant councils have argued in that context. But your lordships will keep in mind, it's a 9-judge bench answering these two questions. It has very broad ramifications on a 25(1) right directly against a state interest outside the context of 25 versus 26. Now, Maharaj, in that context, I submit what is the test which your lordships should evolve. Maharaj, first, I agree with the petitioner's side to the extent they argued the essentiality doctrine has to go. It is not a healthy doctrine at all. The reason is this. My laws have been shown sufficiently that essential, it was introduced in the context when you wanted for the purpose of Article 25(2) to differentiate between religious and secular. And then once that essential came in the constitutional lingo, it cast a shadow on 25(1) itself. I hope I'm making myself clear. It did not arise in the context of 25(1) at all. It arose in the context of 25(2), differentiating religious with secular, but then it became a test for entry into 25(1) at all. That is, if it is not essential, you don't get to enter in the weighing balance of 25(1).
No protection.
No protection at all. The bottleneck was so narrow, if I can use the frame, that nothing went in the bottle, or very little went in the bottle. I am submitting, Maharaj, therefore your lordships will remove this essential for once and for all. And Maharaj, why is it necessary to remove? There are two judgments. One is a South Africa judgment, page 15. It puts the point quite well, and I thought I'll put it. It says that it is not your Article 25 right is not only in cases where you are literally, if you can say, I can use the phrase in North India, they'll say dharm sankat, that either my religion or the secular activity. It is also for things which go beyond the classic obligatory practices. This was a case where there was a young girl. Her name was Sonali Pillai. She was a 13-year-old girl. Apparently, it's a Tamil practice that when a girl attains puberty, she's put a nose stud. So she had a nose stud in South Africa. She went to school with that. The school regulation was no jewelry. So then she was asked to take off this thing. The question was, is this nose stud essential to your religion or culture? And there were different versions, but the final court, the court in South Africa said, it is not necessary that it has to be essential. If it's important to you and the countervailing interest is not that important, you should be allowed. So what we are suggesting now, is from a doctrine of essentiality, your lordships will go into a doctrine of proportionality, bringing it in the balance and then weigh it against what is the countervailing interest. That's the structural change, we are proposing your lordships in the 9-judge will adopt. Essentiality didn't allow you to come in only. You allow it to come in and then you weigh it against the countervailing fundamental rights using the doctrine of proportionality. And that, is in line with two things. Wherever there is a genuine state interest of a high order, of course, a 25 will have to cede to it. There's no difficulty on that. But when there is, even a non-essential practice, and it doesn't actually impact anybody's interest in a major way or only in a marginal incursion, your lordships will allow it. What is the difficulty? As opposed to not bringing it in the balance. Now, kindly have the paras, it puts it very well. Page 15. Para 61. Para 61 at page 15. 61 at the bottom of page 15. I'm quoting from the judgment. The final question is whether the Equality Act and the Constitution apply to voluntary and cultural practices. This question has not yet arisen before South African courts. The school and the GBF have argued that voluntary practices should not be protected or should be accorded less protection, while Ms. Pillai has taken the opposite stance. Now over the page. The traditional basis for invalidating laws that prohibit the exercise of an obligatory religious practice is that it confronts the adherents with a Hobson's choice between observance of their faith and adherence to the law. There is, however, more to the protection of religious and cultural practices than saving believers from hard choices. As stated above, religious and cultural practices are protected because they are central to human identity and hence to human dignity, which is in turn central to equality. Are voluntary practices any less a part of a person's identity, or do they affect human dignity any less seriously because they are not mandatory? 64. A necessary element of freedom and of dignity of any individual is an entitlement to respect for the unique set of ends that the individual pursues. One of those ends is the voluntary religious and cultural practices in which we participate. That we choose voluntary rather than through a feeling of obligation only enhances the significance of a practice to our autonomy, our identity, and our dignity. And over the page, then finally, page 17, differentiating between mandatory and voluntary practices does not celebrate or affirm diversity, it simply permits it. That falls short of our constitutional project, which not only affirms, but promotes and celebrates it. We cannot celebrate diversity by permitting it only when no other option remains. Well, that's the point. It is not only in those cases where it's literally either this or that. Where the Supreme Court has affirmed the necessity of protecting voluntary religious practices. Now, the Canadian Supreme Court is the next judgment. There also, plus they have followed the test and included voluntary practices as protected. They have not limited it only to essential practices. Well, this was a case of a Jewish festival, and they wanted to do something on a balcony, which was a voluntary practice, and the regulation prevented them from doing it on the balcony of the house. You couldn't do it. And in that context, the issue arose. And I will straight away, your lordships will have page 19, which is the test which they propose. And I am suggesting a similar test that your lordships may consider by this court. Kindly have page 19. He or she has a practice or belief having a nexus with religion, which calls for a particular line of conduct either by being objectively or subjectively obligatory or customary, or by, in general, subjectively engendering a personal connection with the divine or with the subject or object of an individual's spiritual faith, irrespective of whether a particular practice or belief is required by official religious dogma or in conformity with the position of religious officials. Well, that's the first test. So even heterodox practices, practices which are not in line with the main, in fact, contrary to it, if it is, that's the next test. He or she is sincere in his or her belief. If that person believes sincerely, your lordships will only test not the correctness of that belief, but the sincerity of the belief. And if your lordship see that the belief is sincere, your lordships will say, okay, you come in the 25-1 in the weighing scale. And then your lordships will balance it with everything else.
Why should we do all these things?
Yes.
In our 25 says conscience. You are trying to restrict your own right now. You start with conscience, thereafter goes into it. So long as I have a conscience to do certain things, I am entitled to convert into belief and do it. Is it not? It's not open to them to venture into that.
It is.
So long as according to the state that it involves a social reform or a social welfare. That's the only test. They will not go into all the other things, whatever they say. You see, whether it is essential or integral. Absolutely, that is not even reflected in another constitutional scheme.
Correct.
You can say 21 and 2, they don't say anything about it. It says only secular or religious. 25-2, even if it is religious,
yes,
power is given enabling provision to test as to whether it involves a social welfare or social reform. Court has to see whether it exists or not. That is a matter.
It's a very small gray area.
And to that extent, we can go into the proportionality.
Absolutely. So
Concedingly, we take it as a religious practice or reform, a religious practice or a belief. Only then 25-2B will come. We got it, yes.
Yes, I'm grateful. Malas,
Yes,
just one thing now. So, Malas, the essentiality has to go now. Kindly on my page 21. When your lordships are testing 25-1 with other fundamental rights, there are three fundamental rights which are in absolute terms, which will always prevail over 25-1. 17, 23, and 24. Malas, they are absolute. Human trafficking, child labor, and untouchability. Those three will always prevail. There's no question of balancing in those three cases. But Malas, when it comes to others, even 19, 21, even 26 for that matter, the proportionality test is the ideal test which can be used, and others have also suggested, to balance between the interest of 25-1 right and those rights.
Para 52 explain it.
I'm sorry, Mulas.
Your para 52.
That's right. I'm correct. That's right. Your lordship is para 52. Except Article 17, 23, and 24, and the aspect of inviolability of body integrity, autonomy under Article 21. If somebody's body is being damaged, that as part of 21, your lordships may consider making is non-negotiable. After that, to resolve any apparent conflict between 25, 26 and other fundamental rights, this court will attempt to harmoniously construct the two sets of competing rights. If it is unable to harmoniously construct them, it must conduct double proportionality analysis to decide which right will prevail. Plus, double proportionality was there in the electoral bonds case. I think Mr. Khambata brought the court's attention to that. That was in the context of whether right to privacy prevails or Article 19(1)(a) prevails. The Justice Chandrachud's judgment that double proportionality is there. But that, my respectful submission is, may not even be needed in most cases. Simple proportionality is sufficient.
25-2B on his own restricts their right in 25-1.
That's correct. All right. That's correct. Now, my lords, the last, just one aspect at page, next page, D, which is page number 24.
Article 17, for example.
Yes.
That is the basis for which there can be a law under Article 25(2)(b).
Yes.
Therefore, Article 25(1) says, subject to the other provisions of this part.
Right. That's the opening words.
There has to be some harmony, in all that.
Absolutely. That's correct. Plus, then one argument was made that deities should also have part 3 rights. I'm just countering that, Malas. Your lordships will make it clear that part 3 rights are for human persons.
On point D, Mr. Sadan.
Yes, Malas.
Unless the issue really directly confronts.
Your lordships are not going into it.
Not,
if your lordships were to go into it, don't give it, because Malas, there are cases today of non-human persons, namely animals, which they say also have. There's one judgment of this court which gave animal fundamental rights in part 3. So Malas, there may be statutory schemes which give them rights. They could be.
Let's not become super religious specialists.
I'm grateful. So that
what deity wants, we leave it to the deity.
That's right. I'm grateful. I'm grateful. Now, Malas, final question: sections of Hindus. On sections of Hindus, Malas, I have one submission. The word section is in distinction to the word classes. Plus, the only other place where sections has been used is Article 29. In Article 29, the word is section in singular, not plural. Section of citizens. I have quoted it, Malas, at page 26 of my written submission. Just have it for a moment. Article 29. Any section of the citizen will have a right to distinct language, script, and culture. Well, section is not the same as classes. Part 3 has used classes in a certain context and section in a different context. So it has to have a meaning different from classes. That is why I'm countering the other side, number one. Number two, my lords, insofar as Article 25 is concerned, it is sections. It's not even singular. In 29 is section. It is sections with a plural. So, my lords, I would respectfully say that at least textually, it envisages the maximum fold within its realm.
Because one speaks about right, one speaks about regulation, that's all. Thank you, thank you.
Well, just one thing, one aspect. Final, I'm concluding only. Well, the only thing is, if your lordships were not to include women in sections, then that word section itself, the interpretation will operate possibly in a discriminatory manner. So the court may not interpret the word section in a way which excludes women, because then the word itself is operating to exclude somebody else and include someone. It is the widest possible amplitude, and it should be given that amplitude. I'm grateful, Manoj.
Not all women who are excluded.
Plus women even from 10 to 50. All women should be included. I'm grateful.
Wait, please, my lords. My lords, I will restrict my arguments and I will not repeat any of the arguments made.
Yes.
My lords, I have written submissions and additional submissions, my lords, just to keep it very brief. My lords, when I went through the constitution, my lords,
5-10 minutes.
when I went through the provisions of the constitution, my lords, I found that the term all persons has been used in only one place in the entire constitution, and that is in Article 25(1) of the constitution. And my lords, if we see Article 367 of the Constitution, that clearly says when a word has not been defined in the Constitution, we can take aid of the General Clauses Act. My lords, may I just draw your attention to page number 3, my lords, of the submissions that I submitted, my lords.
Page number?
And Roman number 6, my lords, it is mentioned. Page number 3, my lords. I've extracted section 342 of the General Clauses Act, where the word persons has been defined. And if I may just rely on that, my lords.
Yes.
42, it says person shall include any company or association or body of individuals, whether incorporated or not. Therefore, by including all persons under Article 25(1), you have not only included individuals, but you've also included the association of individuals and denominations or section thereof. Therefore, 25(1) cannot be looked at in a restricted manner at all to call it an individual right and compartmentalize 26 as a denominational right. My lords, this is also very evident from the Constituent Assembly debate itself. My lords, at page 2, my learned senior referred to Pandit Lakshmikanta Metra's submissions in the Constituent Assembly. I only want to read one line to show that even when the draft Article 19 was getting debated, even then it was understood to only be a community interest and not an individual interest. My lords, at page 2 at the bottom, my lords.
Highlighted line.
Yes, my lords. Only the highlighted portion, my lords. Pandit Lakshmikanta Mehta on 6 December, that guarantee of religious freedom was conceived to ensure that every community professing any religion would have equal rights and facilities to act in accordance. So therefore, it was always understood that 25(1) would not be an individual right, but a community right. Now, my lords, if I may stretch the argument a little further, what does Article 25(1) protect? 25(1) protects the freedom of religion and guarantees two kinds of practices. Number one, the right to practice religion, number one. And number two, it empowers the state to regulate religious practices. My lords, it is my argument that right to practice religion is different from religious practice that is understood under 25(2)(b). Now, my lords, to make that argument, if I may just draw out a few examples, my argument is that right to practice is either an individual's right or a denomination's right, versus a religious practice belongs to the custom. And that is why under 25(2)(b), while regulating social reform, what is regulated or reformed is the religious practice. Now, to give an example, my lords, in Hinduism, Saptapadi is a religious practice. But whether I want to get my marriage ordained by a Hindu priest or by following the Kanyadan Pratha is my right to practice religion. In the same way, my lords, even during the Ganpati Visarjan, the Visarjan itself, after Ganesh Chaturthi to be carried out on Ananta Chaturdashi, is a religious practice. But it is my individual's right whether I want to actually do the Visarjan on the 3rd day or the 7th day or the 10th day. So there is a distinction between the two, and both of these rights, the individual and the community rights, are protected under Article 25(1) is my argument. My lords, the third prong of my argument, my lords, may I just draw your attention to page number 5, my lords. I'll just read only one line, which is the right to propagate. My lords, it was argued that the right to propagate, which was included in Article 25.1, was not originally conceived to be a part of the Article 25.1 text. It was brought in only at a later stage. And the rationale for that, my lords, and I'll just read that one line at page 5 at the bottom, my lords, the highlighted portions. If I may read, my lords. As noted by Pandit Sri Lakshmi Kanta Mehta, this right, which is the right to propagate, was given to all sectional religions, enabling different religious communities to spread their tenets. And my lords, over the next page, 7.6, 7.88, where it's extracted only at the bottom, the highlighted portion, I'll read, my lords. As we read this clause, it is a right given to all sectional religions, and it is well known that after all religions have one objective, and if it is properly understood by the masses, they will come to know that all religions are one and the same. I will just skip the next 3 lines, and I'll read the different communities may well carry on propaganda or propagate their religion and what it stands for. Therefore, in 25.1, where the word propagate is included, obviously, therefore, my lords, the intention was to include not just the individual, but also the community interest. Coming to my next point, my lords, which is that Article 25, if I may so call it, is the maternal right, is the motherboard of all rights, which features not just when we talk about the right of religion, it's not just 25 and 26, but it's also prevalent in 25, 26, 27, 28, and the other provisions of the Constitution. And just to draw this interrelation, my lords, if I may just read from 26, my lords may have 26A, which provides the right to the religious denomination to do what? Number 1, establish and maintain institutions for religious and charitable purposes. If I read this with the provisions under Article 27, Article 27, although is a right given to an individual, because it says no person shall be compelled to pay any tax. So it is an individual right, but for what purposes? If the proceeds of the tax are being used for the promotion or maintenance of any particular religion or religious denomination. So therefore, the language in 27 ties up with the language in 26A as far as it uses the word maintain institutions for religious and charitable purposes. And therefore, the right of the religion is expounded not just in 25 and 26, but also in 27 and 28. My lords, I will then come to the other parts of the Constitution very quickly, my lords. We have page 8, and I will just read the articles without going to the details. Page 8, my lords. There is a heading there, my lords, saying provisions of the Constitution that are affirmations of the rights guaranteed. My lords, are divided into 4 parts. The first part is the individual's right protected in the Constitution under 25.1. The second prong is the denominational right protected by the Constitution. The third part is the 25(2)(b) exercise of the state, one for secular activity, and the second one is for other activities such as economic, political affairs. Quickly, my lords, for just the individual rights protected, if I may see, 15, my lords, Article 16, Article 23, Article 29(2), and Article 551AE are all individual rights as far as they determine the rights of access, rights of opportunity, rights of employment. As far as an institutional right under Article 26 goes, my lords have E, where Article 31 is provided for. And 31 guarantees to all minorities, including on grounds of religion, to establish educational institutions, which is nothing but a right under Article 26A. Thereafter, my lords, the state category. Now, this is a very interesting category, my lords, with regards to the secular activity. My lords, at page 9 at the bottom. And the first provision that I've highlighted as a secular activity exercised by the state in the Constitution is the right of citizenship. Now, my lords, although Articles 5 to 11 nowhere use the word religion in the text, however, when the definition was being debated in the Constitutional Assembly debate, one of the arguments were, can we make religion a ground for getting citizenship rights in India? And that was negated. And I will just read what Sri Alladi Krishna Swami Iyer specifically said, my lords, only the highlighted portion at page 9 at the bottom in italics. May I read that, my lords? But we cannot on any racial or religious or other grounds make a distinction between one kind of persons and another, or one sect of persons and another sect of persons, having regard to our commitments and the formulation of our policy on various occasions. So therefore, religion as the foundation of justifying citizenship was outrightly rejected by the Constitution in furtherance of that secular activity. Article 17 has been touched. My lords, there was a lot of debate regarding personal laws. Now, this is also interesting because Shri Muhammad Ismail, during the debates of Article 19, which is now the Article 25, a specific issue was raised. He, in fact, wanted to add clause 2 after Article 19. My lords, that is at point number C. If I may just read that portion. At page 10, my lords. My lords have that? Nothing in clause 2 of this article shall affect the rights of any citizen to follow the personal law of the group of the community to which he belongs or professes to belong. So he wanted this clause to be added in our Article 25. Shri Baba Sahib Ambedkar, Dr. Ambedkar rejected this and specifically stated that in a secular state, religion should not be allowed to govern all human activities and that personal laws should be divorced from religion. So therefore, this argument of what is the interplay between personal laws and religion was explicitly discussed during the Constituent Assembly debates and rejected by them, that we will not give them ultimate power and the state will have the power to regulate personal laws. Then Article 26D, my lords, where the right of a denomination to administer property is subject to law, and Article 325, where nobody will be excluded from an electoral role only on grounds of religion. These are all the secular aspects of the religion protected by the Constitution, the powers of the state. The other aspect, which is non-secular, which are for economic or political reasons, my lords, is at page 11. My lords highlighted Article 16.5 this morning, where the state is allowed to say that for particular religious purposes, we can actually have certain persons belonging to a specific denomination being appointed. Now, for instance, my lord, Section 10 of the Tamil Nadu Hindu Religious and Charitable Endowments Act specifically says that any person who wants to be a commissioner or an additional commissioner of this endowment provision has to profess the Hindu religion. And once they cease to profess the Hindu religion, their occupation will be taken away. So that is a protection under 16.5, which is a non-secular in that sense. Another provision, my lords, is Article 290A. Now, this is a very interesting article, my lords. It is at page 11. When the reorganization happened, my lords, of state of Travancore and Mysore, and two new states, some new state of Kerala, and some new proportions were added to the city of Madras. There was a discussion about all the Devasam boards saying that because of these reorganizations, all the temples that are in existence, who is going to take charge of them? Who is going to take care of them? So provision was put in the Constitution specifically under Article 290A. And my lords, I will just read that provision, my lords, because it's very interesting that a provision was made in the Constitution to give specific rights to a Devasam board belonging to a community, my lords. 290A. My lords have
Page already?
Annual payment to certain Devasam fund.
Page already?
My lords, page 11. My lords, I'm just reading from the Constitution itself now.
But she's reading Article 298.
I'll just read the constitutional article, my lords. Article 298A, my lords, I'll just wait.
Yes, please.
My lords, Article 290A provides for annual payment to certain Devasam funds. A sum of 46 lakhs and 50,000 rupees shall be charged on and paid out of the consolidated fund of the state of Kerala every year to the Travancore Devasam fund. And I apologize. 290A. Yes.
I heard it as 298. That is the right of the state to trade.
I apologize, my lords. 290 capital A, my lords, is what I wanted to refer to.
Yes, yes.
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 Annual payment to certain Devasam funds. A sum of 46 lakhs and 50,000 rupees shall be charged on and paid out of the consolidated fund of the state of Kerala every year to the Travancore Devasam fund, and a sum of 13 lakhs and 50,000 rupees shall be charged on and paid out of the consolidated fund of the state of Tamil Nadu every year to the Devasam fund established in the state for the maintenance of Hindu temples and shrines in the territories transferred to that state on the 1st day of November 1956 from the state of Travancore, Cochin. So, my lords, this is a provision that was introduced by virtue of the 7th Amendment. Now, this is peculiar because it is an exercise of the state's power to do political welfare in this case, my lords, because there was a reorganization happening, but it is non-secular in that sense because it is for specific Davison boards. So, my lords, with respect to this, the argument that I'm trying to frame is that although explicitly Article 25(1) has been made subject to Part 3 of the Constitution and 26 has not been specifically made subject to Part 3, because both the rights actually confer the same protection, which is the freedom of religion, they have to be read together and not in isolated brackets. And my lords, everyone has read my lords Rustam Kawasji, and I will not read that, but just examples. My lord, the Chief Justice has also in Aligarh Muslim University under Article 27, which does not use the Part 3 example, harmonized it with other features of the Constitution. My lords, coming to the second prong, just quickly, my lords, with regards to the unhappy marriage of the ERP with constitutional morality, my lords, if I may just draw your attention, my lords, to page number 15, my lords. This is, we have just made a table, my lords, and I won't read through the table. I just want to show the unhappy evolution of the ERP practice in the table, my lords, at page 15 of my submissions.
We'll go through this.
Right, my lords. My lords, just what we have said is that in this, if we see in the Shirur Mutt case, they had said that religion has autonomy. In Hanif Qureshi, the test became about optional versus what is obligatory. In Dargah Committee, it became about what is essential and integral and not mere superstition. In Acharya Jagdishwarananda, it became the antiquity test. Then in Shaira Banu, it became what, if you remove this practice, then would it alter the essential character of the religion or not? Therefore, this test itself over the last 73 years, my lords, has seen a remarkable evolution and no standard of...
But we should not adopt any test.
No, my lords. Therefore, the ERP test is not a straitjacket formula.
Yes, okay.
But my lords, another problem is that today, if we were to go into the exercise of what is essential and what is not essential, for example, sati may have been an essential practice, but because it violated certain other features of Part 3 of the Constitution, it was held to be bad. And constitutional morality, my lords, you've given another table. I won't go into that, my lords. I'll trouble your lordships to see the submission.
Not a religious practice, Sati, it was a social practice.
It was a social practice, my lords. I bow down to that. And under 25(2)(b), they are also requiring. And so therefore, my lords, when you look at the essential religious practice, you have to apply the principles of constitutional morality, which is nothing but the essential tenets of the constitutional provision. I bow down to my lords and I'm very grateful to
We
them.
appreciate your outstanding preparation and excellent articulation.
Thank you so much, my lords.
Now, yes, madam, 5 minutes,
Grateful, Lordship. I am so grateful for this opportunity.
5 minutes, please.
Uh,
Then,
Lordship.
ladies, young girls.
Lordship, may I pass on my written submissions? Please.
Yes, this will circulate, you start. please.
Lordship. Lordship, before I answer other things, I will take only 7-8 minutes. I want to take it forward from where Dr. Guru Swami argued. There is a discussion about interplay between Article 25 and 26, and it has not been argued because it has been held by the Honorable Supreme Court in several judgments that whenever there is confusion, there is an ambiguity in interpretation of two articles of the Constitution, the interpretation which is closer to the preamble, that interpretation has to be considered. And Lordship, in Article 25, Article 25 speaks about social justice. It speaks about dignity. It speaks about equality of religious affairs, Lordship. But Article 26, there is no mention of religious denomination or managing the affairs or acquiring the property. Therefore, the interpretation which is closer to the preamble is Article 25, Lordship, not Article 26. Therefore, Article 25 would prevail over Article 26, Lordship. I have handed over a compilation where I have mentioned, those are the loose papers where we have extracted the relevant paragraphs from the judgment, particularly Keshwan and Bharti, where it is said, whenever there is an ambiguity, please refer to the preamble and it will be a guiding light. Lordship may now kindly see, this I mentioned in paragraph, page number 15, Lordship, of my written submissions. I mentioned this thing, Lordship, and then the other thing, which Justice Amanullah said.
You forgot about what we asked you. You complete your...
Page number 34. Lordship, may kindly open page number 24. The central dilemma in this matter, the way forward. What would be the way forward? Like if the practice is held to be like a 10-year-old girl going there and they say it's impure, if it held to be unconstitutional, then what is the way forward, Lordship? The central dilemma, immediacy versus acceptance. The Honorable Court is confronted with the profound constitutional dilemma, one that lies at the intersection of rights adjudication and rights realization, Lordship. This is the dilemma. Lordship, thereafter on page number 35, I have mentioned the Brown Doctrine, rights declared versus rights realized, Lordship. Lordship, what happened in Brown versus Board of Education, Lordship, in US courts, Lordship, there was a case where the blacks were not admitted to the schools run by whites. So it was held to be unconstitutional by the US Supreme Court. But Lordship, when it came to implementation, there was a lot of resistance. This is what is happening in our Shabrimala matter, Lordship. Then the Brown 2 came, Lordship. I have mentioned it at page number 36. Brown 2 said, with all deliberate speed, Lordship, with all deliberate speed, if it can't be immediately implemented, because this is something which is pertains to social conditioning of women, Lordship, here. Because I have, that's why if not immediately, Lordship, then this Honorable Supreme Court also in some cases like MC Mehta versus Union of India, Taj trapezium case, Honorable Court recognized that immediate closure of industries would have socio-economic consequences. Therefore, Lordship, there was a phased transition which balanced environmental protection with economic realities. Lordship, that was worked out. Lordship, even in the Ayodhya matter, mediators were appointed because it was necessary, Lordship, because here also it amounts to social reform. Lordship, I have given the suggestions at page number 39, phased implementation framework, a doctrinal proposal and suggestions on implementation framework in matters involving religious practice and constitutional rights, Lordship. Lordship, there can be educational campaigns, Lordship. There can be, in fact, transformative constitutional educational campaign where the girls can be made aware about their rights, Lordship. And like, then Lordship may kindly read it. I have mentioned it here because otherwise the time will be over, Lordship. Lordship may now kindly go through the moot questions, the question regarding Locus, Lordship, because it has been hanging since the very beginning. My ladyship Nagaratna has remarked that why the women who were living in North India, how could they are not aware of the practices in South India? Why
the North and South who are not devotees?
Lordship, maybe. Lordship, may I kindly take Lordship to one page, page number 8, Lordship. Page number 8 first.
Yes.
Paragraph 9, symbolism of dignity, Ahilya, Lordship. Lordship, I was born in a very spiritual family. In fact, there used to be a dedicated space in our household where the ladies from all the neighborhood would come and my grandmother would recite Ramayana and Bhagavad Purana to them, Lordship. And there was a story of Ahilya, which always came. Now, who is Ahilya? Why Ahilya turned into a stone? I used to ask that time how a woman can turn into a stone, Lordship. I didn't realize those things that time, but now I realize very well, Lordship. The stone becomes a metaphor for silence, for exclusion, for social erasure, Lordship. Now, this is the exclusion of women between ages of 10 to 50 is based on biological attributes. It reflects not theology, but social conditioning, Lordship. Such exclusion is rooted in notions of control, not devotion, Lordship. And impact on dignity and conscience, Lordship. I belong to a small place in Haryana, Lordship. When a young girl is told here, I have seen very closely how the social conditioning, how the social upbringing affects the future of a girl, Lordship. There have been girls. Lordship, it was page number 8. And impact of dignity is page number 9, Lordship.
Page 9.
Yes, Lordship. Lordship, when small girls, young girls, it is their conditioning which is important here. That's why I filed this matter. Lordship, when I was 15 years old, I wrote a book, Tears of a Garland. Now, why a 15-year-old girl would like a book, Tears of a Garland? Because I'd seen the indignity and lack of respect, all those things, Lordship. And those things, and the moreover, the spiritual atmosphere in the home, Lordship. When a young girl is told that she cannot enter a temple and that her presence would render it impure, the impact is not merely physical exclusion, it is psychological and constitutional harm, Lordship. This is the way she is brought. In Tears of a Garland, I wrote, a girl whose family background was that, like, she has to agree, jail low, jail low. Ultimately, she went into a depression and she died. And at the time of marriage, she chose a very beautiful garland for her groom. And that's how I felt now that even that garland
Yes,
could be
please.
weeping.
Just come.
The Lordship, may kindly see page number 7. The Udhav Gopi dialogue, Lordship. The Udhav Gopi dialogue, Lordship, page number 7, paragraph 8. The Bhagavad Puran presents one of the most philosophically rich episodes in the tradition, the dialogue between Udhav and the gopis. When Krishna departs from Vrindavan, he sends Udhav, a learned disciple, to console the gopis. Udhav arrives with the authority of knowledge. He speaks in language of philosophy. Krishna is not merely a person, he is Supreme Brahman, he is present everywhere. You must transcend attachment and realize him through meditation. Lordship, the next page. His message is one of detachment, abstraction, and intellectualization of devotion. Intellectualizing the devotion, Lordship, it was countered by the gopis who said devotion cannot be regulated. Devotion,
Thank you.
Lordship, and then I remember one phrase, like the ladies who used to come to our house, they used to, who told Udhav, Gyan tiharo adho adhuro mano yamat mano. Lordship, it means whatever the knowledge you have, it is incomplete. It is incomplete. Devotion cannot be regulated in any manner, Lordship. Lordship, how now the petition was filed by me because I belong to North India, Lordship, because there was a spiritual background, Lordship, and till the date I regularly go to temple. Since the age of 7, I've been going to temple every day, Lordship. So this was something, when I filed this petition, Lordship, may kindly see page number 11. This was the debate which I had with my father also. When I, as a lead petitioner, choose to challenge this practice by filing a petition before this honorable court, I shared this decision with my father, Lordship.
Madam, how are we concerned with all this? We heard you on legal issue. Please concern yourself.
What he said.
This debate is into family issue. Don't bring it to the argument for the family. We understand. We appreciate
That's
it.
the answer.
Please.
Personal sentiments
Yes.
have nothing to do with these 9 ruthless people.
Sir, I'm not wearing my band, Lordship, because I'm a petitioner also in this matter, Lordship.
Yes.
I'm a petitioner also.
Reserve all those things for even after reference is answered.
My name is Bhakti. Yes.
That's what my sister was saying.
Symbolizes everything.
And my brother's name is Moksha. So
Moksha and Bhakti, yes, we have said. So that symbolizes, Bhakti symbolizes everything. Without Bhakti, you can't reach Moksha.
There is Bhakti and Prerna, no? Both are here.
yes, yes,
Bhakti and Prerna.
yes.
So what is the Prerna after Bhakti with regard to your petition?
She's here.
Lordship, so the seeds were sowed when I wrote Tears of Garland. In fact, I have the copies of my second book wherein I have mentioned about that, and Mrs. Jaising told me to hand over that book also to Lordship. And Lordship, a few years ago, I went to Gangotri, Lordship. And when I went to Gangotri, there were, in fact, 2 traveler buses containing tourists from Kerala, Lordship. I went to Uttarkashi and Gangotri, so I had an interaction with them. I asked them, who goes to Lord Ayappa temple in Sabrimala? So many of them had gone, Lordship. Now, this doesn't make them a lesser devotee of Lord Shiva. They were there for Char Dham Yatra. And en route to Char Dham Yatra, they were visiting to Uttarkashi and Gangotri. I met them there, Lordship. So devotion, Lordship, it cannot be regulated in no way. And after becoming a lawyer, I joined Mrs. Rani Jethmalani and we were running a NGO. And we organized numerous legal literacy workshops, Lordship, around Delhi. And there, the only thing which I observed, because I was the youngest that time, 22, 23 years old, the only task I was given was talking to the women and understanding their problem. This was the only thing. The social conditioning, their miseries arose only from their social conditioning. The belief that, oh, you are a lesser being, Lordship. So when this matter came, when the news reports came, Lordship, Honorable CJ said, that on basis of newspaper report, how can a PIL can be filed lordship? In so many matter lordship, Husainara Khatun. In fact, Professor Upendra Bakshi said that Supreme Court has become Supreme Court of Indians. It was on basis of permanent Katara lordship. So that's our lordship, because that was the trigger, that the seed which was sown at the times of tears of Ogalan, by now it had become a bigger tree. So that's how this petition happened, and
No, we respect your sentiments, everything. We really appreciate what you have given the story. We will consider that aspect.
Lordship.
The only thing, the last only comment is that you refer to Haryana. So that is what I am unable to reconcile, Haryana and Lord Ayappa. Very difficult to reconcile.
Lord Ayappa,
I hope you have heard Surinder Sharma.
Lordship, it's the
You must have heard Surinder Sharma, na?
Our lordship. Because this was what I came across while I was practicing here.
You go and hear Surinder Sharma on YouTube, you will find. Then he gives one story. He says, Lord Krishna has been extremely unfair and very cruel to Haryana. And he will repeat 3 times. Lord Krishna has been very unfair, very cruel to Haryana. So the curiosity, and then he gives answer. बांसुरी तो उत्तर प्रदेश में बजाई और लठ हरियाणा में बजवा दी महाभारत में. This is what he gives the answer. That is very difficult to accept.
The people of Haryana are here. The place is known for raising warriors, lordship, maybe, because when they see something is wrong.
That's all lighter side. You are very, you got emotional. That's why you want to.
Just on locus, on locus.
Lordship.
On locus issue, just one.
Thank you very much. So what we will do is, we will give you half an hour more tomorrow. But please divide your 5 minutes, 7 minutes, 10 minutes, whatever way you want. Otherwise, we will not go.
Your Lordship, may I just take 1 minute, Your Lordship? President of Indian Young Lawyers Association. I think this is much awaited now. This is in the beginning, very fancy questions were there on me. I just wanted to justify for 2-3 minutes, either now or next time, Your Lordship, whatever is convenient.
No, you are asking 1 minute, we are ready to.
All right, Your Lordship. In fact, on 11th of January 2016, when the matter was first, initially taken up by this honorable bench, by the Your Lordship's predecessor, Honorable Chief Justice, that time, Honorable Court desired that the matter is required consideration at length. And in 2006, this petition was filed, writ petition. Our association came into being in 2004. We were quite young, just 2 or 3 years of practice at that time. We all 24 people got together. And then we formed this association having a national character. In this association, we have a women's cell, and Bhakti is part of that, and General Secretary as well. These Bhakti as well as Prerna and Dr. Alka, etc., these are the co-petitioners in this petition. So far as my part as a petitioner, Naushad Ahmad Khan, is concerned, when the matter was filed in the registry through the Secretary General, that time registry raised pertinent question that it is required to be signed as an authorization by the President. So as a locus standi and the head of the organization, Lordship, I was duty bound that when my colleagues are saying this and they are feeling aggrieved, that I was compelled to, or I was duty bound to sign it. So I gave them permission to file it, though our practice was at the very nascent stage. But luckily, Your Lordship, for all together, in 2016, when this petition was taken up, and at that time, immediately after the hearing, after just half an hour, all the key position holders received very serious threats. Even till date, we are into that trauma. We are facing it. We got the security, but that time when the matter was mentioned by Mr. Dave, the then president of the Bar Association, then the bench was reconstituted immediately. Protection was granted. Issue came so far as locus standi is concerned. And so far as the petitioners organization is concerned, we wanted to have this relook on this so far as to eliminate the first portion of it, that Indian Young Lawyers Association, and to remain as number 2, 3, 4, and 5. But the Honorable Chief Justice that at this time signed, this is a public interest litigation. We wanted to carry forward this course and appointing amicus curiae in this matter, even though if the organization or the co-petitioners wanted to withdraw it, we won't be allowing it to do it. This has been culminated in 18th of January order, Your Lordship.
That's why right now we are not going to any technicality. We have heard all of your members also. That's why we heard.
Mr. R.K. Gupta appeared in the matter. He was not being apprised so far as this particular party is concerned. But Your Lordship, with all due pride, we can say today, this organization has addressed at various forums at national and international level. And we have worked very hard. 2 persons are at the bench as of today of this organization. One is holding a constitutional position, other one is a district judge. And rest of them, we 8 are here. We are practicing in Supreme Court, and rest of them are practicing in different high courts of the country, Lordship. Yeah, I'm so grateful, Lordship. This is all we wanted to say.
Muslim brother who suffered due to his Hindu sister.
So we will give exact half an hour, not a minute beyond that. Please now divide your time in between.
I'm so grateful, Lordship, obliged.
Because our problem is that I have some